We will come to order and go on the record. I am Tanola D. Brown Bland of the North Carolina Utilities Commission, the presiding commissioner for this hearing. And with me this afternoon are Commissioners Daniel G. Clodfelter, Kimberly W. Duffley, Floyd B. McKissick Jr., and Jeffrey A. Hughes. Chair Mitchell and Commissioner Kimmerite are recused from this proceeding. I now call for hearing docket number A41 sub 21 in the matter of complaint of Village of Bald Head Island versus Bald Head Island Transportation, Inc. and Bald Head Island Limited, LLC. On February 16th, 2022, the Village of Bald Head Island, hereafter Village or Complainant, filed with the Commission a complaint and request for determination of public utility status against Bald Head Island Transportation, Inc., hereafter BHIT or Transportation, and Bald Head Island Limited, LLC, hereafter BHIL or Limited, collectively the respondents. Petitions to intervene were filed by Bald Head Island Club, hereafter BHI Club, and Bald Head Island Association, hereafter Association or Bald Head Association. Those petitions to intervene were allowed by commission orders issued on March 18th and July 22nd of 2022, respectively. The intervention and participation of the public staff is recognized pursuant to North Carolina General Statute 62-15D and Commission Rule R1-19E. On March 30th, 2022, respondents filed response, motion to dismiss, and answer. On April 1st, 2022, respondents filed a motion that commission take judicial notice or in the alternative for leave to file supplemental exhibits to its answer. On April 22nd, 2022, complainant filed a response to respondents' response motion to dismiss and answer. On June 17th, 2022, the commission issued an order which, among other things, scheduled a hearing on the complaint for today, Monday, October the 10th, 2022 at 2:00 p.m. in the commission hearing room in Raleigh, North Carolina, and established procedures. On July 8th, 2022, the complainant filed a motion to join necessary party. On July 11th, 2022, respondents filed a response to complainant's motion to join necessary party. On July 13th, 2022, complainant filed a reply to respondent's response to motion to join necessary party, as well as a response to, scratch that. On August 1st, 2022, the commission issued an order allowing complainant's motion to join Sharpview Capital, LLC, hereafter Sharpview, as a necessary party. On August 9th, 2022, the complainant filed the testimony and exhibits of witnesses Scott T. Gardner, Dr. Julius A. Wright, Kevin W. O'Donnell, Brandy Monroe, David Cox, George Corvin, and Stephen Boyette, which included matters deemed confidential. On August 16, 2022, the commission issued an order on respondents' motion to take judicial notice and motion to dismiss, which, among other things, took judicial notice of the commission's 2010 order granting partial rate increase and requiring notice in docket number A41 sub 7. Hereafter, for shortcut, everyone may refer to it as the 2010 rate case order, and denied respondents' motion to dismiss. On September 8th, 2022, the public staff filed initial comments. BHI Club filed the direct testimony of David Sawyer, and Bald Head Association filed the direct testimony and exhibits of Alan Briggs. Also on September 8th, 2022, the respondents filed the direct testimony and exhibits of James Leonard, Shirley A. Mayfield, and James W. Fulton, Jr., which included matters deemed confidential. On September 9th, 2022, respondents filed confidential exhibits to the confidential direct testimony of witness Leonard, as well as witness Leonard's public direct testimony and exhibits. Respondents also filed the direct testimony and exhibits of Charles A. Paul. On September 14th, 2022, a consumer statement of position from Robert T. Blau and J. Paul Carey was filed. On September 28th, 2022, Bald Head Association filed a reply testimony of witness Briggs. Sharpview filed rebuttal testimony of Lee H. Roberts, and complainant filed rebuttal testimony and exhibits of witnesses O'Donnell, Wright, and Gardner. Also on September 28th, complainant filed reply comments to public staff's initial comments. On September 29th, 2022, respondents filed a motion in limine. On September 30th, 2022, the complainant filed a verified motion for preliminary injunction prohibiting sale of assets prior to determination by commission. Consumers Blau and Carey filed a second joint consumer statement of position on October 3rd, 2022. On October 4th, 2022, complainant filed opposition to respondent's motion in limine, and respondents and Sharpview filed a response in opposition to complainant's motion for preliminary injunction. On October 6, 2022, complainant filed reply to respondents and Sharpview's response to the motion for preliminary injunction. On October 7, 2022, the commission issued an order denying respondents' motion in limine. Also on October 7th, 2022, commission staff informed counsel for the parties that the motion for preliminary injunction would be heard today prior to hearing and receiving evidence in the hearing on the complaint. In compliance with the requirements of the State Government Ethics Act, I remind all members of the commission of our duty to avoid conflicts of interest, and I inquire at this time whether any member of the commission has a known conflict of interest with regard to the matters before us in this docket. The record will reflect that no conflicts were identified. I'll now call upon counsel for the parties to announce their appearances, and I'll begin with the complainant.
Good afternoon, commissioners. I am Marcus Trathan with the law firm of Brooks Pierce here in Raleigh. And with me, my colleagues Craig Schauer and Amanda Hawkins. We're making an appearance on behalf of the village of Bald Head Island. And if I could, I would just like to introduce the mayor of Bald Head Island, Peter Quinn, who's here with us today as well.
All right, welcome, Mayor. Thank you. Respondents.
Madam Chair, members of the commission, my name is Greg Steiner, the law firm of Fox Rothschild. We represent the respondents, Bald Head Island Limited LLC and Bald Head Island Transportation. And I'm joined by my colleague, Mr. Brad Reisinger, also the respondents.
All right, thank you. Go ahead.
Madam Chair, David Farrell, the law firm of Nexon Pruitt here in Raleigh, and I'm here representing Sharpview Capital LLC.
Thank you, Mr. Farrell.
Good afternoon, Commissioners. Dan Higgins, Burns Day and President on behalf of the Bald Head Island
Club.
Yes, ma'am.
Thank you.
Mr. Commissioner, Edward Finley on behalf of Bald Head Association.
Thank you. That takes care of the appearances. Are there preliminary matters that need to be addressed before we move on to the hearing on the complainant's motion for preliminary injunction?
Madam Chair, there were two items that were mentioned in the email from Commission's Counsel on Friday. Or there's one item that I thought we may want to take care of now or later, your discretion, as well as one scheduling issue that we can address now or later. It's your preference.
Yeah, is one of those matters the confidentiality?
One of those matters is confidentiality. Yes, ma'am.
I'll hear from you now.
No, it was a good question to try to clarify and to make this hearing as efficient as possible, given the amount of confidentiality. I will not speak on behalf of Sharpview, their counsel, but we have had discussions with Sharpview on this. Much of the information regarding the historic financial performance of all the divisions of Bald Head Island Limited, its subsidiary Bald Head Island Transportation, as well as its parking division and its barge division, were provided to the Bald Head Island Transportation Association Authority during that transaction. That was a public entity. It has been shared in a variety of forums in response to questions that have been sponsored on the island. We have tried to be transparent in that regard. So with regards to historic financial data, even of the unregulated operations, while most of that information has been provided pursuant to confidentiality agreements to date that the parties have entered into, we think, given how onerous the hearing would be if we were trying to close and open and seal transcripts every time financial information was provided, and it's largely the information by Kevin O'Donnell, Mr. Julius Wright, Ms. Shirley Mayfield. It's not practical for that to be maintained confidential. So the historic backward-looking information, we will no longer assert confidentiality of that information. With regards to the APA, the asset purchase agreement between Baldhead Allen Limited and Sharpview Capital and its affiliates, and its terms, conditions, and exhibits and schedules, going into detail about the terms of that transaction, that is still considered confidential. So any specific questions, answers, references to specific provisions of the APA, we ask that that be confidential. We don't think that that would necessarily be extensive, but that may come up in the motion hearing that we're getting ready to start and go into. So I will note that. With regards to any questions regarding personnel issues, of course, of individuals who are employed by any of the parties by name, or that would otherwise identify them beyond what's been already publicly disclosed, we feel like personnel information, and that would include specific investors, information about investors of the parties and owners of the parties. We think that needs to be continued to be confidential. We don't think that will be many questions asked about that, if any. And finally, and I may let Mr. Farrell address this, any forward-looking projections of that Sharpview has made, or any methodology that Sharpview has employed that would be confidential, or that would be proprietary to that firm on a forward-looking basis, would certainly be a confidential trade secret. But we think that likely the bulk of the information that's been identified as confidential regarding past financial data, if that is not deemed confidential in the hearing or the transcript, that should address most of the issues. I think that was the source of the commission's inquiry on Friday.
Thank you, Mrs. Stires. Mr. Farrell, did you want to add?
Thank you, Madam Chairman. Mr. Stires covered it. It's just mainly the forward-looking information of Sharpview and their proprietary business analysis and calculations that we would continue to assert confidentiality over.
All right, thank you. Is there anything to add from the complainants?
I guess really what I have are questions, if I might. This is I'm just hearing this for the first time, so I appreciate the considerations with respect to the confidentiality. I think this will assist us in navigating the complexities of the hearing. A couple of questions, if I might. First, with respect to the forward-looking financial information, there's information in those projections, particularly Sharpview, which are not forward-looking financial in nature. They're just statements. Are those now non-confidential, or are you saying that the entire document, including statements which aren't necessarily projections, financial projections, are confidential?
It's our, Madam Chairman, may I respond? It's our position that the documents and the information in the documents themselves are going to continue to be treated as confidential. Primarily, they're in investor presentations that were prepared by Sharpview. And so it seems difficult to separate things out. And so I think we would feel more comfortable to keep those documents confidential, if that's acceptable.
So to answer your question, Mr. Tracy?
It does. And with
Okay.
respect to forward-looking projections, there are some of those that come from Limited as well. I'm thinking of the Mercator report. Can I assume from your response that that would be confidential? That would still be confidential?
With regards to those excerpts of the Mercator report going forward, I think the answer would be yes. So going forward, projections of the McKenna report, those segments, but not the report in its entirety. But you have questions about those sections, yes, those would still be confidential.
Okay, and if I may, there is in addition, some other information that you had not addressed that was labeled as confidential, and we were always a little bit curious as to that. Parking information, the number of spaces, the maps of the parking areas that were designated as confidential and ended up in our exhibits J, W 14, 15, 16, and 3. What's your position with respect to those?
Number of parking spaces, maps, that type of information. And I maybe want to look at those exhibits during the first break, Mr. Trathan, but as you've described them here, they would not be confidential at this point. No need to protect those.
Okay, thank you.
So I appreciate the party's clarification and coming to an understanding with regard to those items
The other
previously
issue-
discussed.
Sorry.
Go ahead.
So we have been able to work through, I think, every issue with regards to order of witnesses and cross and times reserved and presentation of evidence. The only two things perhaps that are still open are whether we would be allowed to make very brief opening statements prior to the presentation of witnesses. We communicated to Mr. Trathan that we would like to have that opportunity. We feel like, given the volume of information that's filed in this docket, that putting some of that in context in 10 minutes or so, that could perhaps be helpful to the commissioner, each side, of course. And then the only other issue with regarding order of witnesses is that the complainant has requested bringing two of their expert witnesses back up at the end to second time to present the rebuttal testimony. We saw no reason for that. If they're here, they present their direct testimony. We feel like it would be most appropriate and efficient to present their evidence all at one time rather than divide their presentation up as the direct and then come back later as rebuttal. So those are two remaining issues.
Okay, on your last one, I'm going to allow them to present the case the way they choose to and to do, to present their witnesses on rebuttal if they choose to. On your first one on opening statements, let me think about that and I'll let you know after we complete the hearing that we have on the preliminary.
Madam Chair, if I could respond briefly to that. I don't see the need for opening statements. If you would like them, we will certainly oblige, but I think the commission has certainly had plenty to read, and we're going to have a little bit of a hearing in advance. So I think it may make sense to just start the proceeding, but however you would like to proceed, we'll.
All right, thank you for that, Mr. Trathan. So as already stated, we're going to start out having a hearing on the motion for preliminary injunction. And before we start, I want to say this: I'll give each side, and I do mean side in terms of alignment, 10 minutes to bring us up to speed or to make argument. It is not necessary to be overly repetitive of what's been filed. Commission has read what you both filed. So I would ask you to boil it down to your arguments and the basics of what are needed or what will be needed to make a decision on this. And then the commission will have questions for you. So we'll start with the movement.
Thank you. Craig
Sharrow.
Gower on behalf of the village.
Good to see you again. Seems like it was just yesterday.
I know I've been away for too long. I had to find a way to come back. As the commissioners are aware, this proceeding presents the question of whether the commission should regulate the parking facilities and the barge associated with the Bald Head Island Ferry. And in the motion that we filed last week, we're asking the commission to enjoin the sale of the parking and barge assets until the commission is determined whether those assets are to be regulated. In terms of the timing of filing the motion, we filed the complaint back in February of this year. They announced the transaction in May. When the transaction was announced, I believe this is in the materials that have been filed, we did reach out to them to try to get some type of reassurance that they would postpone the transaction pending a decision from the ruling, and they were not able to give us that reassurance. And so we tried to work with them to the extent possible before we brought this to the commission, but we felt like we needed to file it given that I believe the 90-day notice expires in the middle of the hearing that we're going to be having. Our concern, and while we filed the motion, is we fear that while the commissioners are hearing about the parking facilities and the barge and deciding whether or not they're going to be regulated, Limited is going to sell those assets right out from under the commissioners' noses. We feel that they should not be allowed to sell the assets before the commission makes a decision about the regulatory status of the assets. And in filing the motion, we're asking to preserve the status quo in the sense that Limited owns the assets right now. And we would like them to continue to own the assets prior to them moving into other owners' hands, because we believe that the transfer of those assets could be implicated by the decision that the commission is going to make in light of the evidence that's going to be put on during this hearing. Regarding the factual merits, we don't believe we need to present any evidence, although we're certainly happy to, because when we filed the motion, it was a verified motion, so all the facts were verified by council member Mr. Gardner, and as well, we filed an affidavit of Dr. Wright, who verified all of his testimony. And so we feel like all of the facts in support of the motion are in front of the commission for purposes of deciding it. And while we'd be happy to put a witness on the stand, we don't think it's necessary, but we would certainly do so if the commissioners had any questions or wanted to hear any specific evidence. In terms of the standard, there's two elements for a preliminary injunction or temporary restraining order: a likelihood of success on the merits, followed by irreparable harm. In terms of likelihood of success on the merits, we did note in a reply brief that we take the position respondents did not actually respond to the argument of the merits on the case, and therefore it's waived. However, should the commissioners want to entertain the merits, I'd like to kind of highlight some of the facts in the law as they apply to those issues. In terms of the facts regarding the parking, most ferries that we think of transport passengers in cars. And the Bald Head Island Ferry is different because the island does not allow cars. Therefore, ferry passengers must park their cars on the mainland in order to use the ferry service. And there's no alternative to the mainland parking, which is, we believe, established through the record before the commission. And the commissioners don't need to take my word for it or Dr. Wright's word for it. If the commissioner have had a chance to read the public staff's comment, there are two, I think, very insightful quotes that I'd like to remind the commissioners of. The first is the following, quote, "The availability of adequate and reasonably priced parking is required for this unique utility service to its customers." Later, they have another quote that along the same lines, and it's, quote, "It would be nearly impossible for customers to use the ferry without an adequate amount of parking offered at reasonable rates." Likewise, the respondents, I believe it's Limited's witness, Mr. Leonard, testified that the commission should, quote, "ensure that parking is available either at the terminal or in a convenient community location." Granted, he doesn't go as far as the public staff, but I think even he would acknowledge that parking is necessary for the ferry. And in fact, I would like to say that without parking, there is no ferry service to Bald Head Island. Practically speaking, it would not be accessible. So in terms of the law, Section 6232 grants the commission general supervision powers over the services rendered by all public utilities. And we rely first on Section 62.3, subsection 27, which defines service. And it says any service furnished by a public utility. So I'm sorry, defines service as any service furnished by a public utility. And this is the important line, including any ancillary service or facility used in connection with some service. So over the course of the hearing, and I think it's in the evidence before you, the parking isn't just used in connection with the ferry service, it's necessary for the ferry service in terms of the public's access to it. We also rely on what I would call the parent corporation definition of utility, which is 62.223C. And in short, it says a parent corporation of a public utility whose ownership has an effect on the rate or service of such public utility can also be deemed a public utility. And given that Limited owns the parking facilities that are necessary for the service, and we'll establish also impact the rates, given that you have to pay for parking in addition to the ferry ticket in order to use the service, we believe that the commission could exercise jurisdiction over the parking facilities under that statutory basis as well. Regarding the barge, The barge, we believe, is a common carrier under the definition under 62-3 subsection 6, which talks about any person that holds itself out to the general public to engage in the transportation of persons or household goods for compensation. And what's important, and I think we'll probably discuss this in legal briefing later, and we touch on this in our comment, including transportation by boat. In other words, this General Assembly identified the use of boat for transporting persons and household goods, and we believe the barge falls within that statutory definition. There's abundant evidence in the record that the barge transports household goods to and from the island, including a very long log that identifies appliances and furniture being transferred on the barge that was provided by the respondents. The barge also transports persons who accompany the vehicle while it's being transported across on the barge. And in many ways, the barge service is simply what you would think of in terms of a traditional ferry service, a vehicular ferry service that transports both the vehicle and the passenger. That is what the barge is, and so therefore we do believe it falls under the common carrier status. In terms of reparable harm, the first point I think we make in the pleadings on this is we focus on 6211 subsection 111 subsection A, and it prohibits the transfer of a utility franchise without the approval of the commission, which shall only be given if justified by the public convenience and necessity. Everyone here agrees that the ferry is a utility franchise, and without the parking at Deep Point Terminal, there is no ferry service. So therefore, we believe that the parking is part of the utility franchise, and therefore it cannot be transferred absent the commission's approval. Likewise, if the barge is a common carrier, that franchise could not be transferred absent the commission's approval. And our concern in not enjoining the transaction until the commission reaches a determination on the merits is that once sold, Limited will have forever deprived the village and ratepayers of the protection of the commission ensuring that that sale of those utility assets was justified by the public convenience and necessity. In other words, once it's gone, you can't go back and say, well, we don't believe you can. We have serious doubts that the commission would have the ability to go back and revisit the transaction once it's already occurred. And so we would like to maintain the status quo so that the commission can reach the decision of whether or not that transaction needs to be justified by the public convenience and necessity before that transaction takes place. There is also the harm of the potential dismemberment of the different operations and assets. What might happen if an injunction is not issued is the barge and the parking facilities could be transferred to Sharpview while the ferry itself is still held by transportation pending docket sub 22 and the transfer proceeding there. So at that point, we could go months with the assets being held, the assets which we believe need to be operated jointly in order for the transportation system to function would be held by separate entities. And also once the assets are in the possession of Sharpview Capital, there's risk that Sharpview Capital could simply flip them again to another owner, and there could be another degree of separation between BHIT, which would at this time still own the ferry, and the parking facilities or the barge, which are interrelated with the ferry. In terms of law, if I could, in preparing for this, I would like to hand up one piece of precedent that I think is insightful on this point, if I may approach.
May.
I've highlighted page 7, and I'll cut to the chase. This is an order issued by the commission in 2014 that talks about 62-111. And it quotes an argument presented by the public staff in this document that talks about assets to be transferred and whether or not they're substantial or integral to the part of the system or the facilities used to provide a public utility service, which is what we believe is here. And the public staff took the position that commission approval is necessary for such a transfer. And the commission in the following line said, we generally agree with the public staff's assessment of the law. And so we do feel like that kind of corroborates our position that key components of the utility system or the utility service cannot be separated and sold to another entity absent commission approval. We'd be happy to talk about the bond if we get that far, but we do believe that what the village is doing here is it is serving a governmental function. It's acting on behalf of its citizens. The only means it can seek to protect its interests is by filing a preliminary injunction with the commission, which has jurisdiction over the services. And so we do believe that we are not obligated to pay a bond. Thank you.
All right.
Thank you.
Mr. Stires.
Members, Commissioner Grace Stiers on behalf of Bald Head Island Transportation and Bald Head Island Limited. In the complaint that was filed in February of this year, the village never requested any injunctive relief to stop any transfer of sale of any assets whatsoever. We moved to dismiss, and the commission itself stated, quote, on page 10 of your order, a thorough review of the four corners of the complaint does not yield any request by the village of Bald Head Island, either expressed or implied, for the commission influence, restrict, or control the disposition or acquisition of any property. It was in the commission's own order and presumably was felt to be sufficiently relevant to be included in your decision not to dismiss the complaint from its very onset as we requested at that point. From BHIT and BHIL's perspective, this request coming here 2 weeks before the hearing is particularly disturbing given the history of the relationship of the parties that are at least worth recounting. Mr. George Mitchell died in 2013. Let me repeat that. The ultimate owner of this ferry died 9 years ago in 2013. And by 2015, management of BHIT and BHL started working on a sales liquidation solution in light of the fact it needed to be sold. Worked on that beginning in 2015, started meeting with legislators, meeting with the governor, meeting with stakeholders, and ultimately meeting with the mayor and the mayor pro tem of the village of Bald Head Island in my office in early 2017. At which time the village said, we support this plan to dispose of the assets by sale to Bald Head if the legislature will create an authority. After receiving that commitment by the village, the legislature, Senator Bill Rabon, introduced a bill to create ferry transportation authorities. The village voted unanimously to create the authority, to appoint directors. And from 2017 to 2020, members on that authority board and worked for 3 years through due diligence for the sale that was needed and necessary after Mr. Mitchell's death in light of the need to liquidate this ferry system. Then it was set for January 5th, 2021 on the LGC agenda to approve the bonds for that sale to occur. On December 15th, 3 weeks before, the village did a 180-degree reversal, changed its position and said, we oppose the sale, the sale of the transaction, sell the assets, the Bald Head Authority, and I have letters to that effect if you would be interested in that. Then 3 months later, March of 2021, the village said, we want to buy the ferry and the parking and the barge and all the assets in 2021. And we're in fact going to get bond approval so we can purchase it. In January 13th of this year, the village wrote a letter to Mr. Paul, the Bald Head Island Limited, saying the transportation system would be best owned and operated by the village. We're informed that you're considering selling this to someone else. Second paragraph. First sentence to the third paragraph. Among other things, the village is preparing to petition the North Carolina Utilities Commission to formally assert regulatory jurisdiction over the parking lots and barge used in connection with the transportation system. Not having received a response to their liking to this letter in January 13th, then in February, 3 weeks later, the petition was filed for this commission that we're here on the hearing today. The village has sunk one multi-year effort to sell those assets, and we believe they are now trying to sink another. And the commission, we believe, should not facilitate a hostile acquisition strategy and continued efforts to stop that sale. That's the context that we're here today for. Sharpview is simply stepping into the shoes of Bald Head Island Limited. So this goes to the issue of irreparable harm. Today, as we sit here, Bald Head Island Limited has never been a regulated utility. There's no certificate to Bald Head Island Limited. It owns the parking and the barge. And likewise, Sharpview's subsidiaries are not currently regulated. So if, and that's a very big if, and I'll discuss that in a moment, the commission were to extend the regulatory jurisdiction over Bald Head Island Limited for the very first time, it would be no different than extending the jurisdiction over Sharpview for the very first time. Notwithstanding the rhetoric of the complainant to the contrary, no one is trying to avoid or outflank the jurisdiction the commission may have under the laws of the state of North Carolina. You, the commission, will make its decision regarding these assets and operations regardless of who owns them. That's what the complaint says. That's what the response to the motion to dismiss says, and that's what the commission has said in its order, regardless of who owns them. Then when you added Sharpview as a party, the commission said on page 5 of its order, by joining Sharpview in the proceeding, the commission avoids any future attempt by Sharpview to relitigate the commission's jurisdiction over the regulatory status of the unregulated assets that it has contracted to purchase. So the decision to add Sharpview means that you have jurisdiction over Sharpview today. They are here, and that's the reason you added them as a necessary party. Now, with regards to the likelihood of success, that is a relevant consideration for any preliminary injunction, of course. Likelihood of success. These assets have been operating in North Carolina, knowledge of the public staff, perhaps knowledge of the commission itself, for over 30 years. The public staff is known, the commission is known for 30 years, exactly the parking arrangements that have occurred at Indigo Landing and now at Deep Point. The barge has operated for almost 40 years, and there's been no assertion of jurisdiction at any time while it's been operating for 30 years. If there is a utility operating outside its authority, I think the commission knew about it for 30 years. I think that the commission certainly could have brought it into a sponte, the public staff could have, or the village could have in the last 13 years. Only after they hear that we're getting ready to sell this to a third party do they file this action. Second, the businesses of operating parking and barge are not found in anywhere or even referenced anywhere in Chapter 62. So I understand the village has done a very good job at cobbling together this argument that they have been able to survive the motion to dismiss. I recognize the argument that they have made about related assets. You're going to hear a lot of conflicting evidence on that over the next 2 or 3 days. But the reality is that parking and barge has never been regulated anywhere under any facility in North Carolina by this commission at any point in time. It's not in the general statutes. It's not in the intent of the legislation. And third, while having a passenger ferry to resort island may be unique and only one in North Carolina, it is not unique around the country. There are lots of examples of passenger ferries around the country that have parking on the mainland. The ferries going to the island, as you'll hear from Mr. Leonard and in the pre-filed testimony you've already read, parking operations are not regulated under state utility regulatory commission regulatory jurisdiction in any state, anywhere in the United States. So if it's been operating here for 30 years and no one's ever deemed it to be a utility, if it's not in the statutes and it's not deemed to be subject to regulation anywhere in the country, how could there be a likelihood of success on that issue in this docket? But that's yet to be determined from the evidence you're getting ready to hear. I will touch on briefly this whole issue of whether this is a government function, and I'll make it very brief. You know, the complainant correctly cited the law that whether it's a governmental or proprietary function in nature, courts consider whether the undertaking is one which only a government agency could engage in. The state of Williams case cited in the reply brief. Not only is this not a function that only a government can engage in, a government has not been engaging in this function for 30 years, quite frankly. Pursuing to purchase the assets in the marketplace over another purchaser and the use of an injunction that was never pled in the complaint is certainly not a governmental function. Or another way of thinking about it, to try to derail the sale of assets by filing a complaint under Commission Rule 1-9 is certainly not limited to a governmental actor. Anyone can file a complaint. Anyone can compete for the purchase of assets. That is a proprietary function for sure. You don't ever need to reach that issue. Mr. Roberts' commitments have taken the availability of parking off the table. He is committed that parking will be available. That's before you. If there are questions that the commission may have of Mr. Roberts or of Mr. Paul regarding their intents, their timing, they are not going to be closing on the sale next week. And I'm happy for them to take the witness stand and for you to ask them any questions that you may like about, and Mr. Roberts will say, I'll proffer his evidence that he will commit not to resell this asset until the commission's has ruled in this docket. He will commit that whatever commission ruling there is will be applicable to the assets, whether it is owned, whether he closes or not, whether it's before closing or after closing. He will commit that this closing will not occur until the commission has decided, has some time. We'll give you some time to rule on this motion. I am glad for Mr. Roberts and Mr. Paul to both take the witness stand for your questions, since that was somewhat implied, and make some stipulations on the record to allay any of the fears that have been raised by the complainant. Thank you for listening to me on this point.
Thank you, Mr. Stiers. Did you want to make a separate argument?
Just very briefly, if I might have a few minutes.
Very briefly, because I wanted it to limit it to the same side here, but very briefly, I'll give you a minute or two.
Well, I just wanted to, as the counsel for Sharpview, wanted to reiterate what Mr. Stiers said about any questions you have from us. We're glad to answer them, but just so the record's crystal clear, we have said in our rebuttal testimony that was filed in this matter that Sharpview intends, after if they are successful in closing on the parking lot, to continue to offer the same level of parking that has been in existence and will not raise rates beyond inflationary increases for, I believe they put in at least 4 years, but we envision that these will be conditions on the transfer in the sub 22 proceeding that is scheduled for hearing in January, that will continue to work with the public staff and the other parties to determine whether an agreement can be reached on those issues. That's our intent. But we've gone ahead and put it on the record as to what our intentions are. But I think we're also, as Mr. Stiers said, we certainly believe this is a solution looking for a problem. We plan to hold these assets long term. We don't plan to flip them to a third party. We're glad to stipulate that is until these decisions are made here, that they don't plan to sell the parking or the barge to a third party. That is not our intent, and we'll certainly be glad to stipulate to that if that gives the commission comfort. I mean, certainly we recognize that a decision in this case will have some impact on the deal, but these are two sophisticated business parties that have already attempted in the APA to allocate risk among themselves. That is a discussion they would have, but Sharpview has investors. They have concerns about the cost of finance, interest rates. I mean, delay hurts this deal. Delay could make this more expensive. You've heard Mr. Stiers represent that we believe that that's part of the village's motive here, is to try to scuttle this deal like they scuttled the authority deal. We've put a team together. We're committed to this project, and we believe the delay would harm us. And since this isn't an equitable remedy, we believe the commission must weigh the equities here. And we don't see any harm to the village or the public, because parking's not going to change, barge is not going to change, operation of the ferry is not going to change after any transfer of the parking in the barge, if that closing occurs. And just quite frankly, as a practical matter, given the due diligence that needs to be done before closing, we can't close on these two assets and any other non-regulated assets until mid-November anyway. So this is not a situation where this closing scheduled for Thursday of this week after this hearing. I mean, it's not like that. And so, Mr. Stires and I aren't the deal lawyers, but we know the deal lawyers. We're talking to the deal lawyers, and we understand that there are steps that have to be made to make that happen. So again, glad to answer any questions. Mr. Roberts is here if you'd rather hear it from him than me, but we're certainly committed to continuing what we believe is the status quo, and that is we've got a contract to buy these assets, and these assets are not leaving the commission's jurisdiction because of the transfer. I mean, the commission's already said in its order adding us that ownership is not the issue. It's what happens to these assets. Are they changed in character after a ruling? And that's a business decision that the parties can allocate among themselves. Thank you
All
for
right.
the additional time.
Thank you. Before we move on to the questions that the commission has, I did intend to ask you about the asset purchase agreement. Excerpts from the asset purchase agreement between Transportation and Limited as the sellers and Sharp View as the buyer, dated May 17th, 2022, were attached to the verified motion for preliminary injunction. And we will take notice of the excerpts in making our decision. However, the commission would also like that entire agreement to be in this record. Would either of the parties object to that and or be prepared to move it into the record at this time?
We could do so in the record. It would need to be confidential, of course, for
It
reasons
will
I've
remain
previously
confidential.
articulated, but I believe it's part of the record in sub 22, so I see no reason why we couldn't move that in the record in sub 21.
All right. Is there any objection?
No objection.
All right. If,
No objection.
if one of you would do the honors, I'll go ahead and receive it.
So Thought Out Transportation Unlimited would like to move into evidence as preliminary injunction hearing motion, Exhibit 1.
It will be
Uh,
so identified.
The asset purchase agreement between Thought Out Unlimited Transportation and Sharp View Capital and its affiliates in its entirety, subject to confidentiality, as a confidential document, subject to confidentiality protections.
All right. And with that objection, that motion will be allowed. All right. Questions from the commission? Commissioner Kleinfelder.
Mr. Stires, thank you for the motion. Just to be absolutely certain about it, the document you just moved into the record on this motion hearing is the same as confidential Exhibit E to the application for transfer in docket A-41 sub 22. Is that correct?
That is correct.
Great, thank you.
I did not have that document in front of me, I will say. I wasn't anticipating, so if there are specific questions to me, I do not have that in front of me. But again, Mr. Paul and Mr. Roberts are the ones in the room most familiar with those documents.
Well, at some point before we shut things down, if someone will correct me that I've misread the docket, if I have. If not, I just want to confirm that the document I'm looking at is the one you just moved into evidence.
It is. Okay.
Okay. I have several questions. In no particular order, Mr. Stires, you were reading from a letter, which I'm not sure whether that's in the record on this motion. Do you intend to introduce it or not?
Yes.
If you don't intend to, I'm going to ignore what you said.
Yeah, okay. I would like to move into the record, and I have copies here.
This is the letter.
As preliminary injunction hearing Exhibit 2,
It will be so identified.
a letter from the Village of Bald Head Island to the Local Government Commission dated December 15th, 2020 on Village of Bald Head Island stationery.
Actually, let me re-identify it as the respondents preliminary injunction hearing exhibit number 1.
Respondents Exhibit number 1. Okay, respondents preliminary exhibit number 1. Mr. Paul will distribute, Mr. Reisinger will distribute a copy to the commission and to council at this time. The exhibit sticker is at the corner, not knowing how it be identified, I would ask you to write in the response exhibit number 2. I'm sorry. response exhibit number
Hearing.
1.
Preliminary injunction hearing, number 1.
Okay, on this one. That's the letter I quoted from, asking the local government commission to take the item off the January 2nd. Then respondents preliminary injunction hearing exhibit 2 is a letter from the Village of Baldwin Island dated January 13th, 2022, stating that it wished to purchase the ferry. So I should make sure that's the January.
This is January 13th. All right, this letter on the Village of Bald Head Island letterhead dated January 13th, 2022 will be identified as respondents. Preliminary injunction hearing, exhibit number 2.
I'm sorry, we make sure I identify that correctly. That's the letter to Mr. Paul. And the Baldwin Island Limited saying that it was going to file a complaint. I got them out of order. I apologize. Then exhibit 3 is the March 21 letter to the local government commission stating that it wished to purchase the ferry. And I'll have Mr. Reisinger distribute that as well. So the second is the letter to Baldwin Island Limited saying it wished to purchase the ferry and intended to file a complaint. And the commission, and then exhibit 3 is the letter to the commission, the local government commission saying it wished to purchase the complaint, the asset, excuse me. So those are the 3 letters that I referenced in my remarks. They're not in chronological order, but I think the record will reflect which ones are which by
All
the
right.
date.
This letter on the Village of Bald Head Island letterhead dated March 22nd, 2021 will be
Is number 3.
identified as respondents preliminary injunction hearing number 3.
Yes, Madam Chair.
And the various readings you were doing were from one or more of these exhibits.
Correct.
Okay.
That's correct. Thank you.
I have, again, in no particular order, Mr. Stires, with respect to action or inaction or whatever you want to call it over the last 30 years, I want to be sure I understand your legal argument there. You are not arguing, are you, that there's some estoppel or latches or waiver against this agency as part of the state of North Carolina, are you?
I'm not.
Thank you. I have some questions about the asset purchase agreement that I think I can ask in a non-confidential way that will elicit non-confidential answers. If I don't succeed, then you let me know and we'll go into confidential session.
And if I
Okay?
don't know the answer,
Well,
I'll respond accordingly.
You have your colleague there with you, Mr. Farrell, who may be able to help you out with the answers as well. And if we need to get testimony, we can. Just a series of questions. Has the outside date, as that term is defined in the asset purchase agreement, has that been changed since the document that is now in evidence as Exhibit 1?
Not to my knowledge. But again, I do.
Have either. Sir, Chad Paul from Bald Island Limited, that outside date has not changed. However,
Excuse me, hold up.
We may
Do
need
you
to
wanna
get this
go
into
somewhere?
evidence. We may need to get this into evidence.
You come to the
I've-
witness
I've got
stand.
several questions of this sort,
And
Mr.
I'm not-
Stires,
and we're
about
not- and
the
we're not
APA.
We're not the deal attorneys on
I
this.
understand, but I need to be sure I can rely on the answers from an evidentiary
I
standpoint. Okay,
completely understand.
got it.
And would you like Mr. Paul and Mr. Roberts both, since they're both the representing parties?
Well, I may be able to ask the questions that either one of them could answer, so it's up to you guys how you want to do this.
There's no objection to you coming up together. I mean, All right, if you place your left hand on the Bible and raise your right. Do you sincerely and solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, you may be seated. Mr. Stires, if you'll go ahead and identify them, just get them identified for the record.
Mr. Paul, would you please state your name and current position for the record, please?
I am Charles A. Paul III. I am the CEO of Baldwin Island Limited and a manager of Baldwin Island Limited, and I'm the president of Baldwin Island Transportation. I've served in that capacity for 11 years.
And Mr. Roberts, would you please state your name and your position for the record as well?
Thank you. Good afternoon. I'm Lee Roberts I'm managing partner of Sharpview Capital here in Raleigh.
Gentlemen, I'll take an answer from either one of you or both of you. If you have different answers, I need to know that also. If you don't agree on the answer, I need to know that as well. But again, my first question is that there is a term that's defined in the asset purchase agreement as the outside date. Has that been changed since May 17, 2022?
The answer is no, but we wanted to be clear. There is a tolling agreement being prepared right now to add some time to that. And so we didn't want to have the answer no, and then a tolling agreement is signed tomorrow.
Well, you answered the second question, because the next question is going to be, is it contemplated that there will be a change?
Yes,
So,
sir. It would have to be based on the proceeding here.
okay. And would it be the contemplation of the parties that if such an agreement is executed, it would be filed as a supplemental exhibit in the A-41 sub 22 docket?
Absolutely.
Okay, thank you. Has there been an assignment of the asset purchase agreement to any person or entity who was not originally a party to it?
No, I think that the only thing we might be is we've allocated potentially where some of the assets may be within the Sharpview affiliates, but no, it's not been assigned to anybody else.
But that allocation would have been among the parties who were parties to the
Already part
original
of the
agreement.
Yes, sir.
Already parties to the agreement. Is there any contemplation on either party's part that there will be an assignment to any other person or party to outside the original parties? to the
Not from
agreement?
seller.
Nor from buyer.
Nor from buyer. Has there been any waiver of any of the required consents listed in Schedule 7.5 of the asset purchase agreement? Do you need to see the agreement in order to answer that question? Again, I'm trying to stay away from asking you the contents of the agreement, which are confidential, but if you need to see the agreement, I'm sure one's floating around.
Yeah, let me just make sure I have. May I approach the witness?
Yes, you may.
Schedule 7.5 lists several required consents. And my question was, has there been a waiver requested or given with respect to any of those required consents?
Not from seller.
Nor from buyer.
Nor from buyer. Is there any contemplation that either seller or buyer will request such a waiver?
No.
No.
Let me back up a minute. This question is going to relate to Section 5.2 of the asset purchase agreement. And the question there is really, has there been any amendment to that section since the original agreement was executed in May? That relates to the pre-closing conduct of the business.
Seller has fulfilled those obligations as written.
And there's not been any amendment to that section.
There is not.
Is there a contemplation that there will be any amendment to that section prior to closing?
Not from
No.
seller.
No, it's not been contemplated.
Okay. And this will apply differently. So let me ask first the buyer, has there been any waiver requested or given of the closing conditions in Section 7.7? sorry to make you read it, but I'm trying to ask you the question without disclosing what that section actually says.
Ms. Gladfelder, can you repeat the question?
Well, those are the seller's conditions, the buyer's conditions to closing. And my question is, has there been any waiver of that condition in 7.7 requested or given? Either one.
There has not been a waiver requested nor given.
Or given. Is there a contemplation that there will be a request for such a waiver made?
There's not, no.
Okay.
It may be helpful just to note that the asset purchase agreement that you have has not been modified.
Well, I was going to ask you a general question at the end, and so you may have saved us some time, but let me go through the steps here. Mr. Paul, you need to look at section 8.7. And the questions I'll ask you there is, again, we're trying to get this on the record here. The question there is, has there been any waiver requested or given with respect to that condition to closing in 8.7?
No, there's been no waiver given. However, I want to be clear as it relates to the items in 8.7. Baldwin Island Limited did pro-offer to the village, even though it does not believe the ROFR has good standing, the right of first refusal. We did a transmittal letter to them, and their 60 days expires on November 6th. So they have till November 6th to say, hey, we want to buy it, or no, we don't want to buy it. So we did, outside of all the stuff, but notice to everybody here that's present, we did send a transmittal letter, even though we do not believe that the ROFR has validity, so that we could solve 8.7.
Thank you for that. Has there been, to your knowledge, I'm going to ask the village's council the same question. Has there been any determination as to the validity or enforceability of the claimed right of first refusal dated August 1999?
Not from a court, no.
Okay. Or from any other tribunal, such as the local government commission?
No, I'm not aware of it.
Or any other administrative agency?
The only thing I would point to is that the Senate Bill 391 that was passed unanimously by the legislature.
Right.
My sense is that the state legislature and two separate governors would not have gone through the process if, in fact, they thought that a local municipality could, in fact, operate and own assets and operations that are also located in a completely different municipality. These things are located in Southport.
You've answered my question. Thank you, sir.
Okay.
You're going to get plenty of opportunity to talk later. I'm just trying to nail a couple of very discrete things down right now. So again, to back up, to just be sure, you've not been asked, the sellers have not been asked, nor have they given any waiver of the conditions in 8.7.
Do not believe we've been asked, and we haven't given any waiver.
Is there any contemplation that you would be asked to do so, or that you would give such a waiver?
I can't contemplate why now, given that we've executed a transmittal letter to the village.
Okay. All right, and now the generic question, and I think I already have the answer to that from Mr. Roberts, is have there been any other amendments to the material terms of the asset purchase agreement other than, for example, changes to the disclosure schedules or updating the disclosure schedules? I'm not asking about things like that, but have the substantive provisions of the agreement been amended in any other respect since May 22nd, 2022? May 17, 2022.
Not from seller's perspective, subject to the tolling agreement that we're working on right now.
Thank you for that. Mr. Roberts, same answer for you?
Same answer. There is a tolling agreement that's been drafted to extend the outside date per your question, and I believe that's the only substantive modification that it makes to the
Okay.
agreement. But that agreement's not been executed.
And I'm sure that if it is executed, and I think your counsel indicated that it would, or you indicated that it would be filed in the sub 22 docket, that of course would be a confidential filing as well.
That's correct.
Correct. Okay. Since you're here, those were the specific questions I had for you, but since you're both here, I want to be sure I understand the nature of the commitments that your counsel was offering to us in connection with the motion for an injunction. I heard several things. I'm not really asking you about what you may do with the assets after you've closed and when this is all over. I'm asking really about where we are sitting here right now today, where the matter before this commission is, should we take any action with respect to the closing, if I can put it in layman's terms. So what's the nature of the commitments that the parties are prepared to make on that question?
So I think there are two specific commitments. One is relating to the timing of closing the transaction independent of this process. So while any buyer would like to close as quickly as possible, once you've assembled the capital, put the debt financing in place, rising rate environment, those all militate in favor of a closing as quickly as possible. Among those reasons is not, one of those reasons is not to try to outflank the Utilities Commission, as our counsel stated. And so as a practical matter, we're not in a position to close before mid-November, and we're willing to commit to not close on these assets until mid-November. What we had contemplated was two closings, one on all of the assets that are currently non-regulated, and as you know from the asset purchase agreement, there's a series of assets that are not part of this proceeding in any way at all. And our hope and plan has been to close on all of those assets, excluding ferry and tram. Again, we're not in a position to do that before mid-November, and we're willing to commit that we won't do that. And then the second part of the commitment is to address the concern that we might in some way flip those assets to another buyer, an unrelated third-party buyer. We've always intended to be a long-term holder of the assets that are at issue here, and it's therefore easy for us to commit on the record that we will not sell these assets on to another party.
I think we may need to confer about what I take your answer, and I thank you for your answer. Whether this needs to be reduced to some form of stipulation or something, I don't know, but we need to probably talk with Commission Counsel about what we need here. Let me ask you this follow-up question. So I understand you, what you said you're prepared to commit to in connection with the question we have before us today. And so talk to me about what happens in the circumstance where you might proceed in the manner that you've discussed, according to the timetable you've proposed. What is the risk that then you later say, well, we don't want the rest of it. We don't want the ferry. What happens then?
Well, I think we'd still be bound by the terms of the asset purchase agreement. And it's hard to contemplate a situation in which we were permitted to buy the ferry, but wouldn't want to. The ferry's already regulated. The sub 22 proceeding is simply a transfer of the certificate of convenience. It doesn't relate to the rate charged to consumers or any other economic aspect of the transaction. So I don't see what would happen from a regulatory standpoint relating to the ferry that would affect our investment decision, and therefore our intention to purchase the ferry as well.
I think in fairness, that's all I really should ask you on that point, but thank you for that. I have one. Well, I have one question for the village's council. If you need to put a witness up about this, I'm not sure it's a matter that would require a witness, but you are not aware, or are you aware of any binding determination as to the validity and enforceability of the 1999 right of first refusal? Has there been a determination by any authority, administrative or judicial, that is or is not binding and enforceable?
Commissioner Clotfelter, I'll take that one. And Charles Baldwin is the village general counsel, and if he needs to weigh in here, please, we'll have them do so. But no, we're in agreement that there has not been any judicial or binding interpretation with respect to the right of first refusal.
Okay, thank you.
Commissioner Duffy?
So are you also willing to commit? I did hear two different things. I heard the November date from council to my left, as well as until a final resolution of the matter. And so your testimony, I'm hearing you state the November date. If circumstances change, though, prior to this November date that you have committed to, are you committed to providing the commission notice? And what amount of notice?
I want to make sure I understand your question.
I heard your testimony to be that the sale of the non-regulated assets would not occur until mid-November. But if circumstances change to where you determined that due diligence had occurred and you wanted to sell at the end of October, are you committed to provide notice to the commission that there is a change of this date? And what amount of notice would you give the commission?
I understand. Thank you for that clarification. I don't anticipate a change of that nature. However, if something unforeseen, well, I won't even, I mean, we're willing to stipulate that we're not going to close before mid-November.
Period.
Thank you.
Commissioner McKissick?
Sure, just one or two questions. And I guess what I want to make certain of is that the statements you've made today, Mr. Roberts, as it relates to Sharpview, that it also applies to the affiliates of Sharpview, which would include Pelican Logistics LLC
Yes, absolutely. Those
and the others.
those are subsidiaries under our, or affiliates under our control,
So there would be binding as to them as well in terms
by all
of.
means.
And then secondly, would you consider not closing until the pendency of this action is concluded relating to whether these assets would become regulated assets or not? Because we don't know if that will occur prior to the mid-November that you have stated. But it could occur prior to that time. It could occur somewhat after that time. But is that something you would be willing to commit to during the pendency of this particular proceeding?
We're obviously eager to be as cooperative as possible with the commission and with this process. We're trying to juggle competing interests. One is the interest of our investors, our financing partner, to close in an expeditious manner. We signed the letter of agreement for this transaction December 29th, 2021, and in any environment, you have an incentive to close as expeditiously as possible. It's especially true when market conditions are as uncertain as those we've experienced in the last several months. So what I would say is that we're willing to make the mid-November commitment, and we're willing to discuss with the commission if additional time is necessary, but we do have to balance those competing considerations.
And let me follow up on that then. When you say you're willing to discuss if additional time perhaps might be needed, would you be willing to do so, I guess, if we provided you with some type of a timeline where you would be required to give notice and we would be, inclined to respond, or how would you?
It would
see that
obviously
occurring?
be very helpful to us to know what additional time we were committing to rather than a purely open-ended commitment.
Okay. And I guess the last question, and it relates to language which I saw in the motion, which is before us at this time, relating to the preliminary injunction. There were allegedly statements which had been made by you relating to the timing of a closing related to the non-regulated assets. Are you familiar with that language that was in the motion indicated that you wanted to-
Regarding a newspaper article?
I believe so.
Yeah.
Could you clarify exactly what was stated at that time, which was alleged, or would you like to provide greater clarity?
Well, I think I said something along the lines of would like to close on the non-regulated assets as quickly as possible. I think I probably, I don't remember for that article specifically, but I certainly told investors that we hoped that we could close in the third quarter of this year. That's obviously not going to happen. But I've been consistent in saying that we hoped that we could close on the non-regulated assets, which for clarity are everything besides the ferry and the tram currently, as quickly as possible for the reasons that I've said, with the recognition that the closing of the ferry and tram would require the certificate of convenience process to take place on its own schedule determined by the commission.
Thank you. I don't have any further questions.
All right, gentlemen, you said you're not in a position to close until mid-November without disclosing any kind of confidential terms or but in a more general way than that. Why is that? Is there a number of steps that need to be taken that would be prohibiting completion of closing before November? And did it have anything to do with the letter that's been transmitted already regarding the ROFR?
No, it's a complex transaction with a lot of assets subject to the overall contract, and just the number of steps that need to take place with respect to due diligence, title work, insurance work. The lender needs to complete a good bit of work. It's all the moving parts that go into a transaction of this nature.
All right, and to your knowledge, to both of you, is there any other litigation pending between these parties that are before the commission today, that's pending any place in any other kind of forum or venue?
No, not by these parties, you mean the village,
The village,
the Bald Head Island Limited, Bald Head Island Transportation, Sharpview Capital?
yes.
Not to my knowledge.
All right, and over at Mr. Trathan's table, same answer?
Same answer, yes.
All right,
Not at this, I will say not at this time.
all right. And I've heard the status quo term used, and there's a commitment to maintaining the status quo. Does that include not closing on the regulated and unregulated assets?
Well, when we talked about maintaining the status quo, I think that was in an operational context, that the users of all of these assets really shouldn't see much of any change in the experience of a user of the parking, the barge, the ferry, the tram, that would maintain the status quo from an operations and customer standpoint.
All right, and as long as the decision remains pending on the public utility status of the parking facilities and the barge, would you agree to, or have any issue with agreeing to give the commission prior notice of a closing, say at least a 10-day prior notice in writing?
Of course, that's easily done. Would be happy to make that commitment.
Yes, as counsel, I also second that. Would be glad to have that and put this in writing in some fashion, as your counsel directs.
All right, while I am highly reluctant, given the time and everything that we have in front of us to do this, I want to offer the village an opportunity to ask a few very limited questions on the commission's questions.
Madam Commissioner, I don't think we have any questions for these witnesses at this time. However, we would, if we could, have a few comments and reply to some of the points that have been made.
All right, just we'll come back to you.
One question.
Yes, Mr. Stires. To
Correct.
clarify on the commission's question.
Yes. In response to both Ms. Brown-Bland and Mr. McKessic's questions, if this closing were to occur and this commission had not yet issued a final decision in this docket sub 21, would you acknowledge that whatever the final decision in this docket or on appeal might be, that it would be applicable to the assets regardless of who owns them?
Yes, of course.
All right. Then, thank you for coming, because we had not indicated we would take sworn witness statement for the hearing portion. So thank you for stepping up and being of assistance to the commission, but you may step down at this time. Mr. Tratham.
If I could just briefly here. So we appreciate the commitment as it stands. We're a little bit mystified why it is unfolded in this fashion. It really seems that the request that has been made, which is simply to hold the status quo intact, is a very typical, usual sort of request in these proceedings. So we're puzzled about all of this. Now, I would like to make a couple of points. One, with respect to, as I understand it, their argument is that they're going to be harmed if they can't close, but they've really not presented any evidence whatsoever of that. Yeah, they would like to start earning money quicker, but that's not evidence of harm. That's just a business proposition on their part. I think the issue is with respect to the commission's authority. How do we maintain the integrity of the commission's authority in this proceeding where that is what is an issue, whether or not the commission needs to approve the transfer? And a couple of things that have not really been teased out here. If this so they're offering through mid-November. We're in mid-October. So under the typical procedures, we'll be filing briefs in mid-November and they'll be closing. And so if that happens, we're kind of in this nightmare scenario. So we now have the most valuable part of these assets, which is parking and barge, owned by someone else. We now have the utility owned by transportation. And for the village, that is a complete nightmare scenario. The ferry, this is the evidence in the record, is in the testimony of witness Wright. The ferry has no rights to use the parking. They don't own the parking. They don't have an easement. They don't have a lease. There's nothing. And we asked them in discovery, do you contemplate a lease arrangement with respect to Sharpview in connection with this transaction? The answer was no. So we've got two different owners. You've got essential property that the utility needs to use that they have no rights to use. So, well, there are intercompany agreements in place with respect to various of these assets, the terminals, some other real estate, but not the parking. Well, with respect to those other properties, do those intercompany agreements, if Sharpview now is owning part of these assets, do those intercompany agreements now have to be renegotiated with a new party? And if so, those need to be filed and approved by the commissions as affiliate contracts. What about the intercompany allocations, the cost allocations between these companies, which they have an extensive protocol for tracking those expenses and recording them? If part of these assets are now owned by another company, how does that happen? And sort of most importantly here, for purposes of a lot of ratepayers, what happens with the $500,000 imputation, which was ordered in the 2010 rate case, which remains in effect? The rationale for that imputation was that it was coming from parking. So now parking is owned by a third party. You have money coming from a third party, which the jurisdiction has not been ascertained by this commission. So then transportation is going to come back and say, well, we need our rates reduced because we're not getting this imputation anymore. These complexities are really enormous. And the overriding picture here that really is, again, I've probably said nightmares now for the third time, for the village, is to separate what has historically for 30 years been operated as an integrated whole, this transportation system. Now, all of a sudden, to take the most valuable piece of this and to sell it to a private equity firm outside the control and jurisdiction of the commission when you've got this transfer proceeding, which may or may not ever happen. You know, as I think you asked, you know, what happens if that's not approved, or what happens if you decide you don't want to acquire the ferry? Those are giant unknowns, and it just doesn't make sense from our perspective that you would leave those sorts of ambiguities out there when the simple solution is simply to move forward with this proceeding. Let's get answers to these questions in due course. Then everybody can move forward with knowledge of what the commission's order is with respect to the jurisdictional nature of these assets. So, thank you.
All right. Did you have Commissioner Clarfeld?
Mr. Tratham, then, simple question. It is the village's position that it's not satisfied with reliance on section 7.7 and 8.7 of the asset purchase agreement and the parties' commitment that they will not modify or waive those.
Correct.
All right, I think that brings us to the conclusion of the hearing on the motion. And I think I'll go ahead and entertain a motion on your exhibits.
We would move into evidence the preliminary injunction hearing 1, that is the asset purchase agreement that has been presented, identified earlier, and move into evidence respondents exhibits 1, 2, and 3, which are the 3 letters from the Village of Bald Head, 2 to the Local Government Commission, 1 to Bald Head Island Limited. They've been previously marked and introduced. And that we ask they be moved into evidence in this hearing.
All right, without objection. All right, that motion will be allowed, and respondents' preliminary injunction hearing exhibits 1 through 3 will be received into evidence, as well as hearing preliminary injunction exhibit 1. And
With the
Mr.
hearing exhibit will be
Stiers.
confidential.
Yes, it will remain confidential, and I was just going to ask, would you get that filed for us?
Certainly.
Thank you very much. At this time, we're going to take a quick break before we come back to resume with the evidentiary hearing. And we'll come back on the record at 3:45. Yeah, once again, besides the matters that have already been entertained, any preliminary matters before we move into the evidence you're here? All right, that being the case, I'll turn the case over to the complainant.
Has the commission decided whether to allow opening statements or not?
I think if your opens can be very, very brief, like, yes, 5 minutes each side. We'll start with the village.
Thank you, Madam Chair. So you've read our complaint, you've seen the testimony of our witnesses, you've heard a little bit in advance of preliminary injunction. So I know you know about Bald Head Island. You know there are no cars on the island. You know it's a unique vacation destination enjoyed by hundreds of thousands of North Carolinians. So we'll start there. But let me get to the heart of the matter for purposes of this hearing. This proceeding is about ensuring continued public access to this precious asset of the state for future generations. We're at a critical juncture in the life of the island. The decision the commission makes here will have lasting impacts. For limited, and I think you just saw that here just a second ago, this is about how soon and how much they get paid on the way out the door. For the village and all those who enjoy the island, this is about preserving the island going forward. Now, the transportation system that currently serves the island was established by the developer of the island. There are three principal revenue generating components: the ferry, parking that serves the ferry and the terminal, and then the barge. You know that the parking barge are not currently regulated, although the commission approved a stipulation in the 2010 rate case recognizing a linkage between parking and the ferry. Now, the parking and the barge are by far the economic engine of the combined enterprise. Our testimony and analysis shows the extent to which this is true. And so the village in this proceeding is asking the commission to confirm what has been apparent to the users of the system for quite some time, that all three components are integral components of a unified, interconnected, common carrier transportation system serving the island, and that they're subject to the regulatory authority of the commission. Now, how did we get here? I just want to kind of reset this really briefly. Historically, it has been in the self-interest of the island's developer to make the transportation efficient and affordable, to induce the public to invest in the island, whether this is by buying property, starting a business, or simply vacationing. The developer is now disengaging from the island, and the sale of the transportation system is one of the last big pieces remaining. The issue of regulation has always been looming in the background. We've cited testimony showing that this came up as early as 1998. But we haven't needed an answer to this question because the developer has always been willing to smooth things over. But now that the developer is stepping back, we need an answer to the question for the future of the island. Now, we've given you legal basis, and the post-hearing brief will tie it all together. But there's kind of a fundamental issue of fairness here that I want to be sure to articulate for you. Having developed this unique community, having induced people from all stripes of life to make investments in the community over many years in reliance on the availability of reasonable access to the community, Limited isn't entitled to just break it all up on the way out the door and pretend like the commission doesn't have anything to say about that. They are trying to divest in such a way that they get paid monopoly valuations for what should be recognized as a fundamental utility business built on the backs of ratepayers. If they succeed, ratepayers will be left paying for all of this with no protection that the assets will remain used and useful in support of the utility operation in the future. Now, you've already heard from Limited, and you'll hear it in the case that no one's ever done this or that. First off, we disagree. We think there's ample evidence that parking facilities have been treated in North Carolina as utility assets. That's not a controversial notion. Pretty much any utility of any size likely has something like a parking lot in their rate base. We've provided you authority for this. But here's kind of the basic point. The fact is that no one on Limited's side of the room has been able to identify a single situation in North Carolina or anywhere else in the nation that presents comparable facts to those in issue here. A vibrant island community that is wholly dependent on a single monopoly provider for transportation to and from the island, for delivery of goods and supplies, and for parking. It's essential to the service. So there's a lot of talk about ferries, this and that, but none of them are on facts similar to what we have here. It's a unique situation calling for a solution that is custom to this situation. And thankfully, our utility statutes are written in a broad fashion so the commission has flexible and sufficient power to protect the public. So thank you very much for your time.
Thank you. Executive 5 minutes.
Thank the chair and the commission for hearing us briefly. I'm Brad Rice here on behalf of the respondents. We'd like to just briefly, more as a grace note to all that you heard in the preliminary injunction hearings than as a formal statement, to address the notion that the village has perpetuated throughout its pleadings and again here today that Limited and BHIT are somehow trying to favor their bottom line at the expense of the public interest on the way out the door. That's really unfair and it's misplaced and it's really misguided. The respondents are engaged, under contract with Sharpview in a fair market value transaction. That's an alternative to what they preferred, which was to sell these assets many $1 million under their fair market value to a public trust that they worked hard to establish. And we don't need to. I'm not going to belabor the point that that it fell apart. And the evidence is pretty clear that the village chose another path and wanted to own the assets themselves. And that's really fine. But then to say that when we turned to identify a purchaser that was very much like us, another private entity that would keep the properties together and make the commitments that Sharpview has made regarding the availability and pricing of parking, I think is a really unfair characterization that we're trying to walk away from the table with unjust rewards for the stewardship that our clients conducted over these assets for a long period of time. It was a graceful consensus solution that turned out not to work. And our clients chose the best options that were available to them. And I think brought before the commission and the public an asset purchaser that's based here, that has concerns about the growth of the island, and has acknowledged that the island succeeding is of utmost importance to them as a company, because that's how the parking and the barge will succeed for them. As a corollary, the village has also suggested, at various times in the proceeding that the so-called inflated value of these assets that are the parking and barge assets that are being sold were inflated on the backs of abusive pricing behavior on behalf of Limited and the conduct of these assets over time. And just for a second, I want to sort of set the template against which that statement's made. And that template is that parking is very affordable on the island. Our clients have a significant investment in the workers and the contractors who are the economic engine of the island, the people that come to the island every day to work and staff the businesses that serve visitors to the island, and the contractors that come out and build it. Those folks can park in the parking lots by buying an annual pass for less than $2 a day. For folks on the island, the longer term folks that park in the lots, they can also buy passes. And those passes allow them to pick between two lots, one a little closer in our campus than the other. And the average price of those spots is under $4 a day. The visitors to the island, the visitors that are coming out to vacation, they pay $12 a day. You'll hear evidence in the case that that's very much consistent, or if not below, what's charged in many similar settings across the country. And all in, if you consider all these prices and all of the exits that we track in and out of our lots, the average of those exits out is $9. This is not a situation where Limited has taken advantage of their situation. They've made a substantial commitment to making it affordable for the people that drive the island to get out there, and they've made it reasonable for people that want to visit the island to get out there. So we just want to make sure that, you know, as Mr. O'Donnell and others come up, we're set against that context that Limited has made a strong commitment for the affordability of the parking, and Sharpview, coming in behind as the partner in the transaction, has made commitments as well regarding the availability of those spaces, and not reducing the number of those spaces without commission consent. And they've made the commitments of at least 4 years on CPIU index pricing for parking that's already very low. The only thing we'd like to add, just as a final note before we get started, is about the barge and about what the barge is and what the barge isn't. The barge is regulated as a freight barge under federal law. It does not carry passengers, and it is not allowed to under federal law. The barge, under the appropriate regulations, is only allowed to have the crew and 12 additional folks. And those additional folks can be drivers of the vehicles that come on and off. It's a roll-on, roll-off barge. And it's more efficient for those people to be allowed to stay with those vehicles. If there are extra folks that come on board, those extra folks are directed to the ferry. We don't treat those, Limited does not treat the people that ride with the vehicles as passengers. They're not charged a fee to ride with the vehicles that they're going to drive off the barge on the other side. The Limited acknowledges that the barge contains all of the supplies that sustain the island. It's never been in question that that's what happens. So all of the fuel tankers and the grocery trucks and the construction supplies and the equipment and the materials that build the houses on the island, they all come across on the barge. And all the things that folks use to set up their residences on the island, whether they're going to live there or they're going to rent them, come over. All the furniture and all the interior furnishings that make up those residences come across. But we agree with the public staff's view of that, in that we shouldn't be subject to the double regulation that the village proposes by suggesting that if Mayflower comes across with the contents of someone's house who's relocating to the island, or if a furniture vendor comes across on the island and delivers household goods, and those folks are regulated as household good carriers under Chapter 62, there's no reason, as the public staff points out, for there to be double regulation for the barge, which is an intermodal carrier that just helps the regulated carriers who move those things make one journey across the river, to allow them to finish their journey. We don't think it's appropriate under 62. We don't think there's any precedent for that regulation under 62.
All
And we
right,
thank you for the time.
Okay, thank you. All right, the case is now with the village.
Thank you, Madam Chair. If I could address a housekeeping matter first. Our second witness is Brandy Monroe, and we had exchanged communications with council, and my understanding is that everyone had agreed to waive cross, and I had also understood from commission staff that the commissioners had no cross. And if that is the case, I would ask that she be excused at the appropriate time, if that's now or later.
All right, Mr. Tratham, if the witness Brandy Monroe may be excused without objection.
And is it appropriate now for me to enter her testimony into the record, or would you like to do that
That's up to you if you want her to be the first witness in the transcript.
That would be fine. I would ask that her testimony, consisting of 6 pages, be entered into the record as if orally given.
There being no objection, that motion is allowed.
She also prepared a summary of her testimony and also asked that that be entered into the record.
And that motion is likewise allowed.
Thank you very much. I would call George Corbin.
Mr. Corbin, left hand on the Bible, raise your right. Do you sincerely and solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, you may be seated. Mr. Tracy?
Good afternoon. Could you please state your name and address for the record?
Yes, sir. My name is George Corvin. My address on Bald Head Island is 105 North Bald Head Line and Bald Head Island, North Carolina, 28461.
Mr. Corbin, did you cause to be filed in this proceeding direct testimony consisting of 9 pages and no exhibits?
Yes, sir, I did.
Do you have any corrections to your testimony?
I do not.
If I asked you the questions in these pre-filed submissions today, would your answers be the same?
They would.
Did you also cause to be filed in this proceeding a summary of your testimony?
I did.
And is the summary true and accurate to the best of your information and belief?
Yes, sir, it is.
Madam Chair, I'd ask that Mr. Corbin's direct testimony be copied into the record as if orally given from the stand.
The testimony, pre-filed direct testimony of witness George Corbin will be received into the record as evidence at this time and treated as if given orally from the witness stand.
Also ask that his summary be entered into the record at the appropriate time.
The summary will be received into evidence at this time.
Witness is available for cross-examination.
I'd like to advise the chair that respondents, BHIL and BHIT, have no questions for witness Corbin.
All right.
No question from Sharpview.
All right. Are there questions from the commission? There are no questions. So, Mr. Corbin, well, I'll hold. Let me see. No, I've already received your testimony. There are no exhibits to this. So, Mr. Corbin, you may be excused.
Thank you, Madam Chair.
That may be a record.
Call David Cox.
Afternoon, Mr. Cox. Thank you. Do you sincerely and solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? All right, please be seated. Ms. Hawkins.
Good afternoon. Please state your name and official address for the record.
Yes, my name is David Cox. I am the IT director for the Village of Bald Head Island. I live in 9853 North Old Town Line in Belleville, North Carolina.
All right, just, Madam Court Reporter, are you hearing? All right, be sure you speak into the microphone. All right.
Mr. Cox, did you cause to be filed in this proceeding direct testimony consisting of 9 pages and no exhibits?
Yes.
And do you have any corrections to your testimony?
No.
If I asked you the questions in these pre-filed submissions today, would your answers be the same?
Yes, they would be.
And did you cause to be filed in this proceeding a summary of your testimony? A summary of your testimony? Did you cause to be filed in this proceeding a summary of your testimony? And is that summary true and accurate to the best of your information and belief?
Yes.
Madam Chair, I would ask that Mr. Cox's direct testimony be copied into the record as if given orally from the stand.
There being no objection, that motion is allowed.
And I would also ask that his summary be entered into the record.
And his summary likewise would be entered into the record at this time.
The witness is available for cross-examination.
Livingston and BHIT have no questions for witness Cox.
And Sharpview,
Sharpview has no questions.
are there questions from the commission? Commissioner McKissick.
Just 1 or 2 questions, sir. In terms of parking and accessibility of parking, I'm leaving your testimony, you speak about parking, the closest parking being roughly about around where the Circle K is on Stewart Avenue. Can you elaborate a little bit more about what kind of parking is available there and how far that is away from the Deep Point Terminal?
The Circle K it's a convenience store that
Yeah.
is the closest commercial parking lot. It's not a public parking facility. It's
I
a
see.
commercial parking area. That's the closest thing to Deep Point that would be considered a parking lot.
When you
And
say-
it's approximately maybe just a small amount over a mile.
Roughly over a mile.
Yeah.
So there's not as if there's parking spaces available where you pay a fee for parking. It's just
And I don't-
relates to the,
Basically, it's a gas station and a car wash with
I
a
see.
parking lot attached to it. It's just the first open spot where, where you could park. But you'd have to make arrangements with the owners. There's no, like I say, it's not arranged public parking. It's just a gas station parking lot.
and is there parking available near downtown South Point?
Well, there are public spaces available in downtown Southport. But that's much farther down. That would be, several miles from the.
Several miles. Okay. And what kind of parking would be available there if you know?
Just storefront parking.
Is storefront parking, and that would be about it?
That would be it.
So basically, the parking available there near the Deep Point Terminal is the only large parking area that's immediately accessible to people who might want to use the ferry.
That would be correct.
Thank you. I don't have any further questions.
Commissioner Duffley.
Good afternoon. I have a question for you. So what is your commute from your house to the point when you
Okay, I live in-
go into work?
Okay, I live in Belleville. I generally take Highway 133, which is about 28 miles. My total travel time is about 35 minutes from driveway to parking lot. And I generally, the parking lot's at 1301 Ferry Road, which you generally park in what's known as the contractor parking lot, which is an employee parking lot. And generally my commute is about 35 minutes.
So no, I'm talking about leaving the house and sitting down in a chair, starting
Oh,
work.
well, in that
What
case,
what
like I
is
said,
your
I would-
total time?
My normal day is I generally take what's called the contractor boat, the 5:30 a.m. contractor boat. It usually arrives the island about 5 minutes till 6. My office is located at the public safety facility on the island, which is on Edward Teach Extension. Takes me generally about 10 minutes to get there. So we're looking at about an hour and a half.
Okay, thank you.
Are there questions on commission's questions?
Nothing further.
All right, Mr. Cox, we thank you, and you may be excused.
Thank you. At this time, the village calls Stephen Boyette.
All right. While Mr. Boyette is coming up, I had neglected to say, it's the commission's intent to adjourn for the day at 5:30, or recess for the day, I should say. Do you sincerely and solemnly swear that the testimony you're about to give should be the truth, the whole truth, and nothing but the truth? So help you God? You may be seated.
Please state your name and official address for the record.
Stephen Boyette. I live at 1101 Porters Lane Road, Rocky Point, North Carolina.
Did you cause to be filed in this proceeding direct testimony consisting of 12 pages and no exhibits?
Yes.
Do you have any corrections to your testimony?
No.
If I asked you the questions in your pre-filed submission today, would your answers be the same?
Yes.
Did you cause to be filed in this proceeding a summary of your testimony?
Yes.
Is that summary true and accurate to the best of your information and belief?
Yes.
At this time, we would ask that Mr. Boyette's direct testimony be copied to the record as if given orally from the stand.
Without objection, that motion is allowed.
We would also move that his summary be entered into the record as well.
And that motion is likewise allowed.
Mr. Boyette is available for questions.
No questions from Limited or BHIT.
And Sharpview?
Good question.
Questions from the commission? Commissioner McKissick?
And thank you for being here this afternoon. I guess want to make certain I understand part of your testimony here. You're indicating that there's very limited parking except where the Deep Point Terminal is located. Is that correct?
Yes, sir.
But you do refer to parking on House Street in Southport.
Yes, sir. That'd be the same kind of off-street parking that was mentioned with Mr. Cox.
So it's not a centralized parking area. It's just on-street parking in front of, I guess, in the downtown area.
Yes, sir.
Okay. And of course, I've never been down here but I've read a lot in this record. I gather there was parking at the Indigo Plantation. Are you familiar with that?
Yes, I worked for the Village of Bald Head Island for a couple years while that was still where the passenger ferry was loaded and offloaded.
And how much parking was available there at that time, if you know?
It was still set up with similar different lots for contractors and then property owners. The amount of spaces, I'm not sure. I believe it's less than is currently at Deep Point. But it was still basically a carded, ticketed access. It wasn't what I consider public parking.
And do you know who owned or controlled that parking area at that time?
That I do not.
You do not know.
Yeah, our parking is handled by our employer in the village, so that I'm not aware of.
Are you familiar with the rates that were charged there? Or
At that time?
yes,
No, sir.
okay. And how would you compare the parking at that Indigo Plantation to the way it is currently over near the Deep Point Terminal?
I would consider it very similar as far as walking distance to the ferry. The access, like I said, it was still a paid access.
And geographically, if you know, what's the distance between where the Indigo Plantation parking would be compared to where the Deep Point Terminal is located? Just give me some sense of relative location of the two.
As far as walking distance,
Walking distance would be great, or if you can say in those terms, or even driving distance. Just kind of geographically, what is that distance, if you might know?
okay, so you want to know kind of where Indigo Plantation parking is versus Deep Point?
Yes.
Okay, Indigo Plantation is kind of central Southport. Deep
Okay.
Point is more of the waterfront directly off the river. The other one was kind of off an inlet. It's more of a centralized, there's kind of an elementary school there, if you're aware of where the elementary school is in Southport. That's where Indigo Plantation is. Deep Point is kind of in the same location as the State Ferry.
And if somebody were to park over at Indigo, how long would it take them to walk over to where Deep Point is?
A substantial part of your day.
Oh, really? Is that far
Yeah,
geographically?
it's pretty far geographically.
And travel time wise, if somebody were taking a shuttle or something, how long? Or
I'd say at least probably somewhere in the neighborhood of a 5-minute car ride.
5-minute car ride? So would it be viable for somebody to park over to Indigo today and still use the Deep Point parking as a terminal for taking the ferry, I should say?
I would say not without some other mode of transportation once you park there.
Okay. Thank you. I don't have any further questions.
All right, are there questions on commission's questions? Mr. Stires?
Just wanted to, did you ever park at Indigo Plantation when the shuttle ran from lot D and E to the terminal?
I did not.
Did you remember there being a shuttle that ran from lot D and E to the terminal?
I do not.
Okay, no questions. I just wanted to check.
All right,
No questions.
all right. Thank you, Mr. Boyette. You may be excused.
This time, the village calls Kevin O'Donnell to the stand.
Mr. O'Donnell, if you please. There you go. Do you sincerely and solemnly swear that the testimony you're about to give should be the truth, the whole truth, and nothing but the truth? So help you God. All right, you may be seated.
Good afternoon.
Good afternoon.
Can you please state your name and business address for the record?
Kevin O'Donnell, business address 1350 Southeast Maynard Road, Suite 101, Cary 27511.
Did you cause to be filed in this proceeding direct testimony consisting of 12 pages and 2 exhibits?
Yes.
Do you have any corrections to your direct testimony?
To the direct, no.
Right.
There was.
We'll get to the redirected rebuttal in a second. If I ask you questions found in your direct testimony today, would your answers be the same?
Yes.
Right. Did you cause to be filed in this proceeding a summary of your direct testimony?
Yes.
All right. And is that summary true and accurate to the best of your information and belief?
Yes.
Did you also cause to be filed in this proceeding rebuttal testimony consisting of 15 pages and 2 exhibits?
Yes.
Do you have any corrections to your rebuttal testimony?
Page 10, line 17. That number 18.3 should read 42.2.
Are there any other corrections to your testimony?
No.
Subject to that correction, if I asked you the questions in your testimony today, would your answers be the same?
Yes.
Did you cause to be filed in this proceeding a summary of your rebuttal testimony?
Yes.
And is that summary true and accurate to the best of your information and belief?
Yes.
At this time, we would ask that Mr. O'Donnell's direct testimony and rebuttal testimony be copied into the record as if given orally from the stand, and the corresponding exhibits be marked for identification as set out in his pre-filed submission.
All right, without objection, that motion will be allowed, and Mr. O'Donnell's direct and rebuttal testimony will be received into the record as if given orally from the witness stand. The exhibits that correspond and were filed with that testimony will be identified as they were when they were pre-filed, as they were marked when pre-filed.
We would also ask that his 2 summaries be entered into the record at the appropriate time.
There being no objection, the summaries are received into evidence at this time.
All right, and the witness is available for cross-examination.
Mr. Stires?
Thank you. Good afternoon, Mr. O'Donnell.
Good afternoon, Mr. Stires.
In your work preparing your testimony today, you reviewed the financial statements of Bald Head Island Transportation, correct?
Yes, I did.
And I think they may be attached as an exhibit to your testimony. Is that correct?
That is correct.
Mr. Stires, make sure you stay in the microphone, please.
You also reviewed the financial statements of the parking division of Bald Head Island Limited, did you not?
Yes.
And in fact, that those financial statements were attached to your exhibit as attached to your testimony as exhibit, were they not?
Yes.
As part of your work for testifying today, you also reviewed financial statements for the barge division of Bald Head Island Limited, did you not?
Yes.
And those sets of financial statements are also attached to your testimony, are they not?
Yes, if I can draw a distinction, please, though. The balance sheet information that I got for the barge came in time to do the rebuttal testimony, but I did not have that balance sheet information for the barge and the direct.
But you did ultimately receive them, is that correct?
Yes, I did.
So my point is, those were 3 different financial statements, were they not?
Yes.
Yeah. And each of those financial statements were audited by RSM separately, were they not?
As far as I know, yes.
Now, you don't dispute the numbers in each of those 3 reports, do you?
No, I have no reason to dispute the individual numbers. I just have to take the numbers that were given to me and run with them.
And you don't dispute the conclusion of the auditors of each of those 3 separate sets of financial statements, do you?
In regard to what?
Well, to the conclusion of the auditors that those are accurate financial statements.
No, I don't dispute that.
Okay. Now, parking and barge are financially distinct from the ferry and tram activities, are they not?
Yes.
And you have no opinions as to the operational relationships of the barge and parking operations of the ferry and tram operations, correct?
Operationally?
Operationally.
I'm a finance person. I'm not an operations person, but I can tell you that it seems like, obviously they are linked. You can't have one without the other, but from an operational standpoint, I believe that there are some shared services, there are some leases. There's a whole lot of intertwining going on amongst the three divisions, but from an operations standpoint, I'm just a finance guy.
Well, you were deposed in this proceeding about Mr. Reisinger, were you not?
Yes.
Okay. And you were asked whether you have any opinions or testimony about the operational relationship. Were you not asked that
Yes.
question? And you said that you did not get into the operational aspects of this at all. Is that correct?
If that's what it reads, that's what it reads. And I think that's what I'm just trying to say here too.
So you don't have an opinion as to the operational relationship of these, how they operate together or not? Just
No. I mean, again, I'm a finance guy. I'm not an operations guy.
Have you actually toured the facilities at Deep Point Terminal, Mr.
No,
Reynolds?
I have not.
Okay. Have you actually visited the facilities at the Deep Point Terminal?
No, I have not.
Okay. Based upon your review, Baldhead Island Limited and Baldhead Island Transportation have maintained separate corporate boundaries of those entities for purposes of financing and accounting and cost allocation, have they not?
Well, there are a lot of intertwinings that are going on amongst the two. As you can go back into the 2010 rate case and see some of those intertwinings. But in terms of the bookkeeping aspect, which I think is what you're asking, then yeah, the bookkeeping seems to be separate, but they were not necessarily separate in the 2010 rate case.
Let me just make sure I'll try to word my questions as succinctly as possible. So we have Baldhead Island Limited as one corporate entity, correct?
Yes.
Baldhead Island Transportation is another corporate entity, correct?
Yes.
Okay. And based upon your review, they've maintained separate corporate boundaries for purposes of financing, accounting, and cost allocations. Is that correct? To your knowledge?
I'm having trouble accepting that because when I go back into the 2010 stipulation agreement, there was $523,000 transfer from the revenues of the parking to the ferry system. That's one of the intertwinings I was referring to. There were some parking restrictions. That's another intertwining I was referring to. There was the lease on the island that was included in rate base of the ferry. That's another intertwining that I'm referring to. So I'm having a little bit of trouble deciphering what you mean. I understand what you're trying to say in terms of there are different bookkeeping aspects of it, but what I'm saying is that there are affiliate transactions going on amongst the three that we have to parse out and understand.
So there are affiliate transactions between unregulated and regulated utilities and lots of examples in North Carolina, are they not?
Yes.
So there are cost allocation rules for those types of transactions, are they not?
Yes, and I think that is what happened in the 2010 rate case with the public staff. There were certain things that were set out in the stipulation, but I'm trying to answer your question about, if they are totally separate. And what I'm just trying to say is I understand your point about the books being totally separate, but I also have to point out that there are affiliate transactions amongst them that tie the three together.
And there's accounting cost allocations for those transactions, are they not?
Per the 2010 rate case, yes.
And per, generally accepted utility accounting processes that this commission expects of a utility to separate costs between utility and non-utility functions, correct?
I did not get into anything of that nature in this proceeding. And so if there are any particular cost allocation functions from barge to ferry or anything like that, I didn't get into that. I saw obviously Mr. Hord's testimony where he allocated certain expenses and allocated certain plant, but whether or not that came from any type of cost allocation manual, I don't know. That was kind of beyond what I was looking at in this case.
So you have no opinion that the costs haven't been properly allocated?
That wasn't my task to determine whether or not they've been properly allocated. I do know, however, that the link that was made per the rate cases, the intertwining that I just talked about, that's there. Those three are there. But in terms of if there are any cost allocations that would be in sync with what the auditor came up with and whether or not those were done correctly or incorrectly, I didn't do that. That was beyond the scope of what I had to do.
So would you agree with the statement from a financial standpoint, they seem to be booking everything on a separate basis to the extent they can?
I think that from everything I've seen, yes. But again, you're asking me if I looked at all the accounting transactions and made certain that they were being all allocated in the proper manner. It appears that they are, but I did not go down that road in great depth.
And you saw no indication that they're not properly booking everything on a separate basis?
No.
That you can't?
No,
They can't.
I didn't dig that far. I wasn't responsible for digging that far.
And I think you've already said it's fairly common for you companies to own subsidiaries that are both regulated and non-regulated.
Yes.
Okay. Have you ever rendered a market valuation of a non-regulated company, Mr. Rebuttal?
Yes.
Tell me a little bit about a market valuation of a non-regulated company that you've valued.
When you get on beyond about 2 years in the past, memory gets a little bit foggy, and when you go back 20 years, it gets really foggy. So I think there was a particular case that a lawyer friend of mine brought to me whereby there was a machine maker that needed to have a value of his business done on a regular and ongoing basis. And there are two ways you do that. Number one, you look at the assets and you look at the net book value assets and say, hey, this is your inventory, this is your building, this is, your fixed assets and so forth. The other way to do that is to look at the income statement and to stream out a number of cash flows and reduce it back to present value. So, and the key point in that is not only the cash flows, but also probably even more importantly is the cost of capital that you use to reduce those flows back to net present value.
So I just want to make sure I understand. I mean, so I was asking a specific instance in which you've rendered a market valuation. So have you rendered a market valuation of a non-regulated company in the past 20 years, to your knowledge?
Yeah, I'm sorry. Yes.
You have?
I have a
didn't-
non-regulated.
Okay, within the last 20 years or so. You said that was over 20 years ago.
It was 20, it may have been right around 20 years, yeah.
Since then, have you done any other market valuations of non-regulated utilities? Non-regulated companies?
Would a municipality be a non-regulated company?
So let's include that. Any market valuation
Yes.
of other than non-regulated companies or municipalities?
Non-regulated or municipal. I've done one for a municipality in Florida.
Other than what you've mentioned here, have you ever done a market valuation of a non-regulated utility or a municipality other than what you've discussed right here in the last few minutes in your career?
I'm doing my best to remember. All right. Well, one of the things we do in my business is I value industries. And I have a family money management business where I write reports for them. And less than a year ago, I wrote a report on the oil industry, recommended to buy. Seems like I was right on that one. But yeah, I mean, I've written reports like that for my family's money management business, but those are overall industries.
Have you ever analyzed the financial statements of a parking company or parking operations other than those at Deep Point?
No.
Do you know what the typical capital expenditures are for a parking company?
Typical, no.
Okay. Do you know what the typical operating expenditures are for a parking company?
Typical, no.
Did you compare the financial performance of the Bald Head Island Limited parking operations to the financial performance of any other parking company operations?
No, I did not.
Have you ever analyzed the financial statements of a barge or maritime company other than the one you operated by Bald Head Island Limited?
No.
Do you know what the typical capital expenditures are for a barge company?
No.
Do you know what the typical operating expenditures are for a barge company?
No.
Okay. Did you compare the financial performance of the Bald Head Island Limited barge operations to the financial performance of any other barge company operations?
No, but I didn't think that it was needed to do any of that in the course of this work I was doing. It was, I'm not sitting here trying to figure out how the valuation of these three separate entities compares to other entities. I'm trying to figure out as a whole what their class rates, excuse me, their rates of return were standing alone. So I wasn't tasked with coming up and saying, hey, how does the value of this compare to barge A or parking B? That's not why I was hired.
You know, there are other ferries that over time in the past have been regulated by the North Carolina Utilities Commission. You're aware of that, I'm sure.
No, to be honest with you, I
did not know there was any.
I don't get down to the coast very often. I'm sorry.
So you've never looked at any other ferry operations,
No.
financial performance?
I mean, I know the state of North Carolina owns some ferries, but beyond that, I don't know.
So other than Bald Head Island Ferry, you haven't analyzed the financial statements of any other ferry companies?
It's like I said just a moment ago, there was no need for me to. That was beyond the task of what I was needed to do here.
And therefore, you don't know what typical capital expenditures there may be for a ferry.
No. Yeah.
And you don't know what the typical operating expenditures would be for a ferry either.
No, again, there's no need for me to know that.
Okay. Let me shift gears for a second and ask a question regarding something you are very familiar with, I know, which is rates and rate making process. You've been involved in that many, many, many years. So, in an accountant working in that arena, you're very familiar with the concept of rate shock, are you not?
Oh, only too well.
Okay. So let me ask you, what would be your definition of rate shock, Mr. O'Donnell? The concept of rate shock.
I was asked the same question on Thursday of last week in a case in Texas. And I define it as anything whereby a customer wasn't expecting a set rate increase. I mean, for example, the case I just completed, the overall rate increase is 7, but there was a certain class of customers that were getting an 89.7% increase. That's rate shock. They weren't expecting it. I'll take it a little bit closer to home, because when I leave here, assuming you're kind enough to let me leave at 5:30 and I can get down to Stantonsburg, rate shock to them is a 30% rate increase, where I had to go and recommend, because of the price of gas has gone up so much. Those customers had just dealt with a 15% rate increase, and then I came back a few months later and did another 15% rate increase. They weren't anticipating that. So that's rate shock to them. But if you go out ahead of time and tell people, because this is what I've learned in all my years of doing this, is that if you inform people ahead of time that, hey, we got some serious things going on here. We got Putin invading Ukraine, driving the price of gas up. And then you come back in and they understand that, and it's not necessarily rate shock.
You, early in your career, you served on the public staff, is that correct?
Yes.
Yeah. And you've certainly been in the room when rate case settlements have been negotiated with the public staff, have you not?
I'm assuming yes.
Involved in settlement discussions with the public
Yes.
staff. Is it your experience the public staff can express concern about the magnitude of a rate increase and the rate shock it may have on the using and consuming public?
Absolutely.
And many utilities try to reach an agreement with the public staff and other interveners in order to avoid the risk, time, and expense of a rate case hearing. You would agree with that, wouldn't you?
I'm sorry, can you say that again?
That many utilities try to reach an agreement, a settlement, in order to try to avoid a contested hearing. in a
Oh,
rate
yes.
case.
Yes.
That's fairly common, is it not? To try to reach a settlement with public staff.
Yeah, oh, absolutely. Try to hit a settlement with the public staff, yes.
In order to avoid rate shock, and sometimes a utility can't increase their rates to a point that the utility might otherwise be allowed to earn a rate of return and a level of profitability. Isn't that true? They can't earn what they otherwise might because they're limited by rate shock.
No, I think there are different ways you can tackle that animal. One is to phase in rates. So if you know that a company needs to raise their rates 15%, but there will be rate shock, then you do 7.5% one year and 7.5% another year, so you get up to that point. There are ways to deal with that.
But in the first rate case, they're not able to achieve the increase that they may otherwise need to what would otherwise be a rate of return on their rate base. You'd agree with that?
In that scenario, yes, but but at the same time, you can put those deferred revenues in a deferred asset account and recover them at a later point.
Were you yourself involved personally in the 2010 rate case for the ferry?
No.
Okay. Do you know what the general ticket price was prior to that rate case in 2010?
No.
Not being involved in the 2010 rate case, you have no firsthand knowledge whether rate shock was a concern in that rate case, do you? You just don't know.
I don't know, but I know that there all the concessions that were made in terms of ferry obviously had the public staff a little bit concerned, but whether or not they were concerned about rate shock, I can't tell you.
But as a general principle, when concern about rate shock is a factor raised by the public staff, rate that may be a limit on how much a public staff would support a rate increase. You would agree with that general statement?
Oh, yes. I mean, no one likes to have rate increases, period. And rate shock is definitely something that you don't want to deal with. And I've been in front of boards for a long time, and I've had to talk about 30% rate hikes. It's the worst feeling in the world when you know that you're dealing with people that cannot afford those kinds of rate hikes, but the alternative is that the utility you're dealing with is hurting.
You've testified in your testimony, you've stated the fact that ferry operations, the ferry operations of Bald Head itself have not been very profitable.
That's correct.
And typically, you would agree, you would agree typically that when you see an entity that has got a negative net income, they don't stick around very long. They're spun off or sold. You would agree with that, wouldn't you?
That's true.
Yeah.
Which made me.
Are you aware that Bald Head Unlimited worked for over 6 years to try to sell the ferry operation to the Bald Head Island Authority before hearing my arguments earlier today?
No, when I was first hired to do this case, I Googled, read a lot, kind of stunned. I did not know all the details that were involved in this, but it was absolutely fascinating. It's a fascinating case.
So, so you didn't know until I referred to it today that Mr. Paul and Ms. Mayfield met with the village mayor and Mayor Pro Tem in 2016, 17 to discuss the sale to the authority and the efforts to sell it at that time?
I think that goes beyond the scope of my testimony, though, because I'm a finance guy.
Yeah. Well, but you've expressed a theory, and I want to explore a little bit about that theory. So you were not aware about the legislation that was adopted in 2017, because that was kind of beyond the scope of what you were looking at, correct?
Well, I found that when I Googled it.
Yeah. Do you know anything about the creation of the Bald Head Island Transportation Authority and its efforts to purchase the ferry from 2018 through today, from the authority's perspective?
Only what I read online at the Wilmington Star News, and Commissioner Raven, I believe it was, headed that up. And then I read a few news articles about it, but that's been several months ago.
Based upon what you've looked at and what you've heard, you would agree that Bald Head Island Unlimited was trying to sell its utility asset to an unregulated entity during that time. You had no reason to dispute that, do you?
To be honest with you, everything I read in all those articles just got me confused. I didn't know whether or not they were trying to sell. I didn't know whether or not the authority was going to take it over. I saw newspaper articles that quoted numbers, but I wasn't quite certain how all that was going to happen. I mean, again, I'm just a finance guy, but when I read these things, I'm like, something doesn't quite make sense to me. The authority and its credit rating concerned me, and I wasn't quite certain how all that was going to work out, whether it was going to be a lease, whether it was going to be a sale, I didn't know.
Let me back up generally. So we're not talking about necessarily this transaction, but it's a general proposition. If a utility owner, hypothetically, so generally, a utility owner was working diligently to sell a utility asset.
Right.
And in fact, to a non-regulated entity.
Right.
And in fact, even had an asset purchase agreement negotiated with that entity for that sale. Under those circumstances, it wouldn't make sense for the utility to go through the process of a contested rate case, would it?
I don't see how that plays into it.
I'm just asking, I just asked the question, would they,
I don't.
likely, in your experience, if a company is at the eve, have you ever known a company, let me repeat the question. The utility owner was working to sell a utility and even had an asset purchase agreement signed. They wouldn't come into the Utilities Commission and ask for a rate case, and a contested rate case increase, would they? They wouldn't need one.
Objection. He's already asked this question.
I'm looking for an answer.
I don't believe he received an answer, overruled.
Should I answer?
Yes,
Oh.
you instructed the answer to the
Um,
best of your knowledge and in your
yeah.
experience.
My SCANA, Dominion Resources. That was an example where I was involved in it, and they were trying to sell it. But there was a rate case going on, and the rate case was going on at the same time they were trying to sell it. And my understanding was that unless Dominion Resources got a certain valuation or promise that the failed summer nuclear plant was going to be included in rates, it wasn't going to happen. So I think that's a point where something like that would have occurred where, yeah, you could have a rate case and still try to sell it at the same time. It's a little bit south of us.
In that instance, they're doing a rate case to try to increase a value of the utility, are they not?
They were trying to, they were trying to increase the rates, but the value of the utility had been pretty well hammered when all the news broke about who knew what in regards to when on the Bechtel report. So that was a case in which, as long as Dominion got the rates that they needed that included the nuclear plant recovery, then they were going to go ahead and go forward in the deal. But if they didn't, they weren't going to go through on the recovery of the deal. That was my understanding of the case.
In that situation, the surviving entity, the purchaser of the asset, was still going to be a regulated utility, was it not?
Yes, it would have been, and it still is a regulated utility, and customers did have to pay for the assets.
So my question is a little different. My question is, if the utility owner was working to sell to a non-regulated municipality, public authority, it wouldn't make sense then, because it wouldn't affect the value. It wouldn't make sense to come in for a contested rate case before selling it to a non-regulated utility, unlike the SCANA Dominion scenario.
I don't know how to answer that, Mr. Stires, because I don't think it's going to matter. You know, if you have a $100 million asset and you're trying to unload it to I'm just going to use Duke here. No offense to Duke, but I'm just going to use Duke here because everyone knows Duke. If Duke's got a $100 million asset and they're trying to unload it to a merchant generator, and would they necessarily worry about a rate case? I would look at that and I'd say, well, it depends upon what is going to happen to that $100 million asset, because if I'm Duke, I'm going to say, hey, listen, we fully depreciated this asset, and that $100 million is going to go flow back to your ratepayers. And so we're going to go ahead and sell this asset to the benefit of the ratepayers, and we're going to lower your rate increase.
Would it really matter to Duke in that situation? And would they come into a rate case for that scenario, for that one reason? And that's
For that one reason?
Yeah.
No, but they come in to rate cases at, various times throughout the year, but for a single reason. I mean, you're filing to increase your rates. You wouldn't come into a single reason of selling it is not a rate case. That's a totally different docket.
On page 8 of your testimony, you expressed a theory about the regulatory status, that the regulatory status of parking was a reason that BHIT hadn't come in for a rate case in the past several years. That's your theory.
Yes.
Have you ever talked with Mr. Paul about why BHIT had not come in for a rate case since 2010?
No.
Did you talk to Ms. Mayfield about why it had not come in for a rate case since 2010?
No.
Have you talked with any employee, agent, attorney about why BHIT had not come in for a rate case?
No, but I will say that I put this direct testimony out and it could have been rebutted and no one told me why.
Well, you'll enjoy later in this hearing and this cross-examination. So did you talk with any board members of the authority, of the Bald Head Island Transportation Authority, the Susan Rabin or anyone else, about whether Bald Head Island Transportation would come in for a rate case while they were pending the purchase?
No, but well, that's one of the things that got me confused when I was reading all those newspaper articles is with the authority, whether or not they would be regulated here at the Utilities Commission.
Have you read the statute 391, which says they would not be regulated by the Utilities Commission?
I remember there was a statute created on that one, yes, but whether or not Bald Head Island will come in for a rate case at that time, I don't.
And you haven't
No.
talked with anyone currently on the public staff about why Bald Head Island Transportation didn't come in for a rate case?
No.
So you have no direct evidence for why BHIT did not come in for a rate case since 2010?
Well,
Direct evidence.
I had an assumption and I had a theory that made perfectly good sense to me.
I think you've been doing accounting work. You've answered some of these questions. I'll try not to repeat it. You've been doing accounting work for utilities in North Carolina for over 35 years,
Yes.
roughly. And this is the first time you've ever looked at a ferry utility
That's
in your
correct.
career. You would agree that Bald Head Island Ferry is a unique operation among North Carolina utilities, would you not?
Yes.
Okay. And you've noted that in your deposition that Bald Head Island situation is different from what you'd ever seen before. Correct, Mr. O'Donnell?
Yes. I mean, it's, I deal with electric, gas, water, all around the country, but not this.
The scope of your engagement for this docket did not include evaluating the prudency of any cost of service, did it?
No.
And so you don't have an opinion that all the parking expenses weren't properly, prudently incurred,
No.
reported. Also, the scope of engagement didn't include evaluation any of the assets, whether all of the assets in the parking department financials were in fact used and useful.
No.
And in fact, you assumed that all the assets on the balance sheet for the parking department were in fact used and useful for the parking because you accepted that number.
Yeah,
On the balance sheet.
let me back up and say this. There are different sets of books. When you say used and useful, that's a regulatory term.
Mhm.
But some of the numbers I took were financial statements. We don't look at used and useful in financial statements. We look at used and useful for utility plant assets. So, I looked at that and I said, well, I'm assuming that these are booked properly, whether or not they're used and useful, whether or not the public staff will come in and negatively adjust the assets downward because they're not used and useful. I didn't go down that road. So I looked at the 2010 material by Mr. Horde, and then I looked at the financial records that were provided to me in discovery.
The commission itself has never determined the cost of service for parking operations at Deep Point, have they?
As far as I know, no.
And the commission's never valued the parking facilities assets of the parking for rate-making purposes, have they?
The public staff has.
Commission has not ever valued all the parking facilities assets for rate-making purposes, have they?
Commission, as far as I know, has not valued those assets, but they did approve the stipulation where Mr. Horde did evaluate what it would be if the parking was regulated, and he made a $523,000 adjustment from parking to the ferry. So he basically treated the parking as if it was a regulated asset.
Had you talked to Mr. Horde in preparation for your testimony in this
No.
docket? This is the easier question then. The commission's never determined cost of service for barge operations, have they? For the Bald Head Island
You
barge.
talking about rate design, cost of service?
Cost of service, for how much cost of service for barge operations. In any docket, anywhere, this commission's never determined cost of service for barge.
The reason I'm hesitating with that, I think the answer to that is no, but you have to understand, in my world, going around the country, there are two different definitions of cost of service. One is basically, financial statements, and the other one is rate design. But so when it comes to cost of service on the financial side, I think what Mr. Horde did, the answer to that would be yes. But if you're talking about cost of service on rate design, the answer to that is no.
And likewise, the commission's never valued barge facility assets for rate-making purposes, have they?
I'm sorry, can you repeat that?
The commission's never valued the barge facility assets for rate-making purposes, have they?
Not that I'm aware of, no.
Let me step back again, not talk about this particular transaction, but in general rate-making principles. When a utility purchases or constructs a used and useful asset, it's allowed to add that asset to rate base at that time, correct?
Yes.
And once it's in rate base, it's entitled to recover a reasonable rate of return on that asset once it's in rate base, correct?
On its undepreciated, yes.
And it is entitled to recover its prudently incurred cost of service.
Yes.
Part of that cost of service is depreciation, is it not?
Yes.
Part of that cost of service is taxes that it's paid on that asset.
Yes.
And I think you said it's entitled to recover a rate of return on the investment that's in the rate base.
Yes.
Okay. Now, let me those general rate making principles. Now, for an unregulated asset, something that's not a utility, owner of that company, if it's not regulated, may or may not earn a profit. Correct. It may be a profitable company or an unprofitable company.
Absolutely.
Its revenues may or may not exceed its expenses in a given year for an unregulated company. Is that correct?
That's true.
So you would agree that investment risk profile for an unregulated company is very different from an investment risk profile for a regulated company as a general principle.
I've been doing that work for 37 years, yes.
And I think you said you haven't evaluated the financial performance or return of any of the parking operations in your career.
No, I haven't done that. My focus has been on the utility arena, but again, I do write reports from time to time for firms up in the Wall Street area.
But regarding parking
No.
operations, you haven't evaluated the finances.
No.
And you wouldn't know, are you familiar with Sharpview Capital?
Heard the name, I really don't know them all that well at all.
And so you don't know what other investments they have made in the past in other companies, do you?
No, I don't.
And you don't know what investment opportunities they may have at any given time?
No,
don't you?
not at all.
Let me shift gears a little bit, talk about rate of return on investment, ROI. something you are very familiar with. Return on investment basically is a ratio of net operating income over total rate base. That's general
Generally, yes.
mathematical. In other words, you take the net operating income, and that's basically the numerator of,
Right.
of return on investment, and the total rate base is the denominator. Is it
Right.
not? Yeah.
For utility rate making.
For utility rate making, I'm in the utility rate making arena here. But that mathematics, if the net operating income is higher, if the numerator goes up, then the ROI is higher mathematically.
Assuming that the rate base stays the same.
Assuming the rate base stays the same, that would be correct. You'd agree?
Yes.
Yeah. Now, if the operating income stays the same, let's talk about the denominator. If the total rate base is higher, then the ROI is lower because you have a larger. You'd agree with that?
Yes.
Okay. Conversely, if the total rate base was lower, the ROI would be, of course, higher.
Correct.
In the ratio. In your work in this docket on behalf of the village, you reviewed the filings and documents from the last Bald Head Island transportation rate case.
Yes.
And the commission did approve a rate-based total number for ferry and tram utility in that 2010 rate case, did it not?
Yes.
Okay. You yourself have prepared numerous rate case filings for lots of utilities over the years. Mr. Haven't you, as an accountant?
Utilities, but more on the consumer side.
Okay. But you're familiar with the rate-based filing requirement?
Yes.
Rate case filing requirements?
Yes.
Okay. And typically in a rate case filing, the utility files a schedule of the plant and service and accumulated depreciation, correct?
Yes.
Okay. Plant and service should include the assets that are used and useful in providing the utility service. That's kind of what plant and service is it not?
Correct.
Okay. Did you review the rate case application and testimony in the 2010 rate case for Bald Head Island Ferry?
Yes.
Ms. Shirley Mayfield filed testimony as the utility CFO and prepared most of the exhibits and schedules based upon that testimony that you reviewed?
Yes.
Okay. And the exhibits and schedules included a plant and service schedule, did it not?
As far as I can remember, yes.
And I didn't mean to test your memory. So let me, may I approach the witness?
Yes, you may.
I'd like to hand you an exhibit that CWO, is that right? Initials?
KW.
KWO cross exhibit number 1. Subject check. Does that appear to be the exhibits that were filed as part of the 2010 rate case? Not Ms. Mayfield, we have one of their name. We have copies. Yeah. Subject check, does that appear?
Yes.
Case schedules filed in that 2010 document sub 41, case 41 sub 7.
Yes, I have no reason to doubt it.
So let me.
All right. Before you go further, let me identify it. This exhibit will be identified as KWO cross-examination exhibit number 1.
It is really hard to read pages. document labeled PWO Crossing City 2. Still not, still isn't read, but it's Mayfield Exhibit 1, Schedule 2.1, Plant and Service Accumulated Appreciation and Depreciation Step. Maybe a little easier. You see that?
Yes.
Subject to check, does that appear to be Ms. Mayfield's plant and service schedule filed in the rate case in 841 sub 7?
Yeah, I have no reason to doubt that.
All right, before you go further, I want to identify this as KWO Cross-Examination Exhibit 2.
So that schedule, the plant and service accumulated appreciation, depreciated expenses includes category of vehicles, does it not? To the best that you can read that, Mr. O'Donnell.
Yes.
And then on the next page, it's got a category called machinery and equipment. On the second page, it's got
Yes.
2.1.
Yes.
And then there's a category called computer hardware and computer software.
Yes.
The category on the next page of boats.
Yes.
And then on the last page, again, also additional machinery, equipment, computer hardware, computer software. Those are the categories of exhibits in this plant schedule.
Yes.
Okay. Going back to KWO cross-examination exhibit 1 from docket 841 sub 7. Ms. Mayfield calculated, an original cost rate base towards the bottom of 3,702,198. That was basically, this is the schedule 2 is her summary for the rate base that was part of the application, correct?
That's correct.
Let me approach the witness again.
Yes, you may.
Um, exhibit marked KW cross-examination exhibit 3. Ask if that appears to be the late filed exhibit Jim Ford filed in document number 841 sub 7.
It does.
All right. This exhibit will be identified as KWO Cross-Examination Exhibit number 3.
And again, it's hard to read, so if I may approach exhibit, I'm going to hand to you an enlargement of Ford's exhibit 1, schedule 1A as KWO cross-examination exhibit 4.
It'll be so identified.
It's just a page. And would you agree that appears to be Mr. Hord's adjustments to the initial application and the public staff's recommendation of rate base in A41 sub 7?
It does. He has revised here, so I'm assuming this is what they finally settled on.
Okay. And do you have any reason to disagree? Okay, let me back up. So that rate base after adjustments and the settlement amount on the far right column is an amount of $3,943,335. Is that the rate base settlement calculation?
Yes.
Okay. And those are the adjustments from Ms. Mayfield's initial company amount, which is the left-hand numerical column of $3,702,156. That was the number that was in Ms. Mayfield's initial application that we looked at earlier, correct?
I'm be honest with you, Mr. Stires, I'm getting a little bit lost in the numbers that you're presenting to me here. I think at the end of the day, what you're trying to say is that the net plan and service under the settlement of far right-hand column under column K is $3,943,335 versus
Correct.
what Ms. Mayfield filed at $3,935,344. So we were off by about $8,000.
So they made adjustments during the course, as is often the case in a rate case.
Right.
Have you reviewed the rate case order by the commission in that docket?
Stipulation, yes.
Actually, order by the commission.
Yes, I think I did read that. It's been a while, but I think I did.
Well, I guess just for, even though the commission's already taken judicial notice of it, just so the record is clear, I'll mark that KWO cross-examination exhibit 5, which is if I may approach the witness, which is the order by the commission in that docket 841 sub 7.
Okay.
And in that order, the commission.
It'll be so identified as KWO cross-examination exhibit 5.
Thank you. And in that order, the commission found the rate base for the utility to be $3,943,335, the same number as recommended in Mr. Hord's late filed exhibit, correct?
Yes.
And that rate base total did not include any parking assets or barge assets, did it? That total of the plant and service.
The plant and service, let me get this right. There's an adjustment, if I remember correctly, there was a lease on the island that went into rate base to reduce the revenue requirement. So there was an island lease that went into rate base to reduce the revenue requirement. See if I can find it. Because, you know, as you see, Mr. Stires, there are offsetting increases and decreases in all of these numbers. That's what all the settlement adjustments are for. And here is a BHI terminal in rate base right here that increased 363,503.
But that did not pertain to parking, car parking.
Oh, yeah.
Car parking or barge, did it? That, so that had
It
nothing
it
to do
had
with
to go,
parking.
I think you're right. It had to do with limited, and whether it was, parking or whether it was in, barge. I'm not certain whether or not that terminal was booked in which of those two, but it came from limited and it went into the rate base.
That was a lease by the ferry of the terminal building, correct?
Okay, yes.
So it was the lease for the ferry terminal building from BHIL.
So
Okay.
limited owned the building and that was the lease that went in there.
But
Okay,
that was the terminal for the ferry operations, not the parking assets themselves.
okay.
So you would agree that there's no assets in that rate base number that were parking or barge assets?
No, the only parking would be what we previously talked about was on the revenue side,
And not in the rate base?
not in the rate base.
Okay. So just about finished, and I realize we're pushing 5:30, so I want to see if I can wrap it up for the next 12 minutes. So we talked about ROI is basically a ratio with the total rate base in the denominator, correct, Mr. O'Donnell?
Yes,
And mathematically, if the denominator is lower, you agreed that ROI would be higher,
yes,
given net operating income. So, for example, if the rate base was the same as net operating income, the return would be 100%. If you had, if you basically had a number that was the same as the net operating was over the rate base and you were earning dollar for every 100% rate of return, what would it be?
yes,
Okay. Mathematically, if the rate base were 100 times, however, if the rate base was 100 times the operating income, then ROI would be 1%.
that's correct.
Okay. In your KWO1 rebuttal exhibit, your calculation of total rate base for everything, parking, barge, ferry, was 8,978,096 in your exhibit, rebuttal exhibit.
Sorry, it's kind of like trying to find the needle in a haystack. All right, I'm here.
So your calculation shows a rate base of everything. Your number is 8,978,096.
Yes,
96.
yes,
And you combined everything from the financial statements that you received, correct?
yes, updated through December 31, 21.
And you noted earlier that the regulatory accounting and financial statement accounting, can be different or two different concepts, are they not?
Yes,
Okay. Is it your understanding that that SharpView is offering to purchase the assets of parking, barge, and ferry for $56 million?
as I sit here right now, I don't know what the number is. I've heard some numbers. I don't know what it is.
Subject to check, and if for purpose of a hypothetical, let's assume that SharpView was purchasing the parking, barge, and ferry operations for $56 million for purposes of this illustration.
Right.
That's the court reporters. Our next exhibit 6 costs, it's 6. So just from as a mathematical exercise, probably Rich. David, the cross generation exhibit 6 talked about how rate of return is a function of rate base. If the denominator in your calculation was $56 million, we assume that estimating income is the same, then that mathematics would provide a rate of return on investment of 4.38% mathematically, would it not?
Based on a market value of $56 million,
Just the mathematics. That's what the.
That's, I can't argue with the math, but you know, you're mixing a regulated net operating income with a market value. And we would never do that in regulatory rate making, because then we're getting back to the issue of Ms. Mayfield and I discussing fair value versus book value and so forth and so on. I won't argue with your numbers, but the premise behind them, I disagree with.
Understood.
We're gonna hold up right there. Thank you, Mr. O'Donnell, for that answer. We're going to identify the one-page mathematical document as KWO Cross-Examination Exhibit 6.
Thank you very much.
And
Maybe just a few more. I'll be finished by 5:30, I think.
well,
Or we can finish now and I can finish up tomorrow.
well, based on what you've heard, is the village going to have redirect?
Yes, we will have some redirect.
So, Mr. O'Donnell, we did not get you back on the road to get it back up north. So, we're gonna end right here for the day in terms of the evidentiary hearing. I want to turn our attention back to the hearing on a preliminary injunction. During that hearing, Transportation Limited and Sharp View agreed or offered to provide the commission with a stipulation. Commission's going to take you up on that, and we would like the stipulation between the parties to the agreement, to the asset purchase agreement, to it include what you offered to include, but also to include specifically stipulation not to buy or sell any assets subject to the asset purchase agreement on or before November the 18th, 2022.
Right.
And that asset purchase agreement has been received into evidence here, and it's also in the it's been filed in the sub 22 docket. To also stipulate to provide the commission at least a 10-day notice in this proceeding of any closing date on any asset that's subject to the asset purchase agreement, and stipulate to provide to the commission at least a 10-day notice in this proceeding of any proposed waiver, modification, or amendment of any of the material terms or provisions of the asset purchase agreement, including the provisions of Articles 3, 5, 7, 8, or of Schedule 7.5 without limitation. Well, including without limitation those. Is that clear?
I'll try. Hopefully we got enough people in the room taking notes so it will be clear by the time we put it on. Put it down.
And we would like that to be filed by the end of the day tomorrow.
Okay. No problem. We'll do that. And if I have not written down my notes correctly, we will amend it to make sure it comports with the instructions today, but I think we'll be able to communicate that.
All
Yes.
right, and this is not a ruling on the motion for preliminary injunction. We will hold that in abeyance
We understood.
for the time being.
Okay.
All right, I will adjourn the or not adjourn, but recess the proceeding for today, 4 minutes early. And we start tomorrow at 9:30.
Thank you.
Thank you.